Yes. Attunement.
So your age has been relaxed.
My yes.
Has been submitted by the learning council for the petitioner. The petitioner has been called for the interview in pursuance to a recruitment process initiative to fill up the post of MPS tomorrow. It will, under such circumstances, this matter again on 28th of May 2026. Mr. G. Bushel appeals to the court.
This matter was filed in 2024, and during pendency, my lord, there have been a lot of litigational developments. I pray, my lord, your lordship may close it or withdraw it, giving liberty to file a fresh, my lord.
How can there be a liberty for contempt?
No, my lord, there have been.
There is a mediation.
If advised,
Contempt is on the face of it.
li-
You can't withdraw contempt after this withdrawal. Contempt withdrawal is never heard of.
No, lordship may use the word close to tell liberty. My lord, there are litigational. Even lordship, kindly look at the latest order in the order sheet.
Mister, I will drop the contempt, but I'm not going to give liberty to you. You take the call on that.
In that case, my lord, I in this same this thing, I will have to file, my lord, additional affidavits and all. Lordship may do that.
What is the direction passed?
Last order, my lord, there was some review, read appeal, then then my lord, the review application. Now, all this during the pendency, my lord. They will come.
So there is a direction to refund.
No, yes.
And then
Then, my lord,
ultimately,
ultimately, my lord, the division bench said, all right, you furnish a solvent surety, they will give you the money. Last December, I filed their solvent surety, repeated representation is still not given. Then the case, these are the latest developments.
so there is a direction to in the division bench for compliance.
That's it.
There is a direction in the division bench for compliance with the directions passed by the learned single judge.
That has not been done.
So then why you are withdrawing it?
In spite of me, because I was required to file a my lord solvent surety, my lord, covering that amount in case in future they go for some form of this thing. So I have already given that. Even then, they are not. These are all subsequent developments, my lord. That's why I am saying, or if your lordship is, my lord, saying that the contempt cannot be, then
Contempt
allow,
cannot be withdrawn.
let it be posted, my lord, after a week, my lord, I will file additional affidavit
It's the
stating about the latest
the
development.
learned senior counsel appearing on behalf of the petitioner submits that
Latest developments.
that would not be proper on the part of the petitioner to withdraw the contempt application, taking into account that this court had already taken cognizance of the issue. So the petitioner would, on the other hand, like to file an additional affidavit.
My lord, about the subsequent litigational developments.
File an additional affidavit.
About subsequent developments may lordship may record.
That again is outside the scope. You file whatever you will look into it. Additional affidavit. This matter again on 18th of May 2020.
No, my lord, it's slightly early, my lord.
Why?
Slightly early, my lord. I'll file immediately. This might written to my lord, bring it to the notification code. One letter, right?
Then the matter will be listed after filing of the additional affidavit.
28 of.
After filing of the additional affidavit, matter will be listed. Next. Mr. Barbara, I passed an order to the effect that to be listed after you file the additional.
Listed on both.
File first.
Oblige lordship, that will.
What is this?
Also, this petitioner had challenged the appointment of the respondent number 5. Now, Lordship, during the pendency of the writ petition, Lordship, from the affidavit filed by the respondent, it has come out, Lordship, he has also been removed and another person was appointed. The respondent,
Nothing remains.
but I have no instruction to withdraw, Lordship.
Who are you?
I am I was working as a Malikam cleaner in the office of the residential bungalow of the district Judge Kokrajar, Lordship.
And
Lordship, I served there for 1 year, 6 months, and without notice, Lordship, I was terminated.
is there a requirement of issuance of a notice to you?
Lordship,
Where the appointment letter which says?
page 15.
You are a contingency worker.
Page 15. Lordship.
Yeah, Bhagavati. Anyways, what do you want?
There are 2.1, 2.2 and 2.3.
Now, this particular person, you were issued a particular call letter.
Lordship.
Then
Lordship, I served for 1 year, 6 months. Then, Lordship, the respondent number 5 was appointed.
now, Mr. Das, what is happening?
Lord, after the petitioner, after discharge of the petitioner, the respondent, private respondent, he was appointed. He was also subsequently discharged. And thereafter, one Mumu, I have stated, my lord, para 2.1,
One,
one Mamu Narjari. He was engaged on contingent basis. Thereafter, regular recruitment was held, wherein he also participated. He was unsuccessful in the selection. So that is, nothing remains in my humble submission also.
Mr. S.K. Das, the learned counsel appearing on behalf of the petitioner, Mr. H.K. Das appears on behalf of the Gauhati High Court. The present writ petition has been filed. Assailing the discharge order dated 31/5/2023, as well as the subsequent appointment of the respondent number 5 by an order dated 7/6/2023. The petitioner have also sought for appropriate directions that the petitioner should be continued with should be restored to the post of Mali cum cleaner under the establishment of the respondent number 3. The materials on record show the materials on record, and more particularly the affidavit in opposition filed by the respondent numbers 1, 3, and 4 shows that in pursuance to the discharge of the petitioner on 31/5/2023, the petitioner had participated in some recruitment process and was unsuccessful. The respondent number 5, who was appointed in pursuance to the said recruitment process, was, however, discharged on account of being overqualified. Under such circumstances, this court also does not find any good reasons to interfere with the impugned order of discharge of the petitioner, inasmuch as merely because of the fact that the petitioner was appointed on a contingency basis, the petitioner does not have a right to continue in respect to the post beyond the terms of the appointment. Consequently, this court does not find any merit in the writ petition. The writ petition accordingly stands dismissed.
Item 4, my lord, we have received instruction from Office of Chief Engineer, my lord. There are disputes and discrepancies in the bill, my lord. I would like to bring that through affidavit.
What is the direction?
Direction is
11,
Pending bill.
my lord.
How much? 3,10,417. Direction was given to pay within a period of 3 months. Isn't it? Why haven't you paid?
Yes, my lord, there are discrepancies in his bill, my lord. His bill is disputed, my lord, after verification by chief engineer. So I would like to, my lord, file an affidavit.
So you just say that upon verification, it was found to be disputed. Back over. Then we ask him to appear before the filing before the competent court of civil jurisdiction. Back over. Where is that? Where's the instruction?
Instruction, my lord, I
In your
have to take pre-print, my lord. I just got it in the morning, my lord.
Mr. Ibota, would the learned counsel appearing on behalf of the petitioner submits, on behalf of the respondents submit that in pursuance to the order dated 28/10/2024 passed in WPC number 2206 of 2022, due verifications were carried out and it was found that the amount so claimed by the petitioner is disputed. It is the opinion of this court that the said aspect be brought on record so that appropriate directions can be passed. The affidavit be filed on behalf of the respondents on or before 11th of May 2026. List this matter again on 15th of May 2026. Abbas.
May I please, your lordship? My lord, contempt petition for non-compliance of order dated 10/6/25. My lord, at page 13.
Non-payment.
Yes, my lord.
How
Vehicle
much?
hire charges. 12,05,874.
Why you are not paid after having admitted
Lordship,
the
I
amount?
am the respond number 2, Lordship. I am the joint secretary. I am not the proper party, Lordship.
Why?
Still, Lordship, it should have been the commissioner secretary or secretary, Lordship. Still, Lordship, I have taken instruction from my office and there are letters which were communicated to the deputy commissioner, Lordship, but things have not come from them, Lordship.
That cannot happen like that.
Those things may be given to me, Lordship. I will communicate it.
How much amount?
My lord, 12,05,874.
What is the name of the person?
Siddheshwari Dev.
Huh?
Siddheshwari Dev.
What is the document which you are giving Mr. Gugoi?
The proposals which are sent to the home department, they have sought for documents mostly regarding.
No, the fact that yesterday had filed a contempt in the High Court pending liability in connection with the higher charges which is went. Now this is written to the additional secretary. Home.
23 also we have sent it after.
Additional secretary home, yeah. This was given in 2023.
After that, the image given a letter to us, certain documents and accordingly.
Okay, we let us meet the additional secretary home. Who is this? Additional secretary. Joint secretary.
Maybe, Lordship, but since he is the joint secretary, he could not collect it directly, Lordship, since he is not dealing with the matter. My Lordship, my client, Lordship, he is the joint secretary of Home and Political. He doesn't,
Why you, when you were a party to that writ petition,
Lordship.
why didn't you say that I have nothing to do?
Lordship, I think it was disposed on the same day, I think, Lordship.
No.
I am not
kindly-
aware, Lordship.
No, kindly
I'm
see
not.
the directions. Paragraph number 7. In view of the respondents having admitted they are liable to pay to the petitioner, all the respondents are directed to ensure that the payment. So direction is also given to the respondent number 6, who is the joint secretary. Now you cannot say that you have escaped.
Lordship, I cannot escape, Lordship, since case is filed here, Lordship.
This order was passed in the year 2025.
Lordship.
Direction was to be paid within how much? 3 months. 25. Yeah, by 10/9/2025, the payment ought to have been made. Provide the head of accounts of the Home and Political Department. This attached. Huh? No, I'm having it on 11th of May. Provide the head of account of the Home and Political Department, will attach it. In the meantime, if you pay, very good. If you don't, we'll attach it.
Lordship, those documents, if these are provided to me, I can communicate with the concerned department.
What
Lordship.
documents?
These things he had provided, Lordship,
Sir,
because
you see-
as per my instruction, Lordship,
see,
see my instruction, Lordship.
Mr. Bhagavati, what you, he, or all these respondents keep on doing, we are not bothered.
Lordship.
There's a direction passed to make the payment within 3 months. You should have made the payment within 3 months.
Lordship.
Failure to do so, that is your lookout. You should not have admitted, you should have said, we have not verified. But once you admit, you are to pay. Or give an undertaking on your behalf that you will be paying the interest at the rate of 18%. 18%. He is also happy. 18%. And these 18% shall be these 18% shall not be taken from the state exchequer. It will be deducted from the salary of all these containers. He's also happy, you are also happy. Therefore, this is an application filed for willful and deliberate violation to the order dated 10/6/2025, passed in WPC number 3870 of 2024, wherein the learned court bench of this court had specifically directed the payment of rupees 12,05,874 to the petitioner within a period of 3 months from the date of receipt of the certified copy of the said order.
Lordship, may I interrupt 1 second? Lordship, further what instruction I have, furthermore, the expenditure involved is debitable head of account is given to me, Lordship, for the financial year 2025-26. And Lordship, it says that against which the entire allotted budget has already been exhausted. As such, payments shall be made from the
Mr.
budget provision of the
Bhagavati,
ensuing financial year
Mr. Bhagavati,
26-27.
wait. One should know how to use the money
Lordship.
and use the services. If you don't have the money, though, you should not have taken the services. You have taken the services, now you are bound to make the payment. This is the direction. Otherwise, file an appeal against this order. I'm not concerned with that. And don't disturb, both of you. Take your seat. Directed to pay the entire amount to the petitioner within a period of 3 months from the date of receipt of the certified copy of the order. The certified copy of the said order was served upon the respondents, upon all the respondents by way of post. And the service was duly effected on 10/12/2025. On account of non-payment of the said dues within the period of 3 months as directed, the petitioner when did you serve?
My lord, it was served on 26/6/25. Thereafter, my lord, on 9/12/25.
Where is the receipt for 23/12?
26, my lord. Postal receipt at page 28, my lord.
Huh?
28,
Postal receipt won't do. Where is the acknowledgement?
29.
This is on 10/12.
Yes.
So 10/12, how is it 3 months over?
No, my lord.
When you
Initially
filed
it
the
was served on
petition?
23/6. Initially, it was served on 26.
We don't know whether it was served.
It was, my lord, page 21.
How do we know that it was served? Show me the.
My lord, 21 and 23 were hand delivered.
Huh?
Page 21 and 23, they were hand delivered.
Where?
Page 21, my lord, the senior there.
21.
Page 21.
This is only to the district commissioner
Yes, my lord. It was and AEC.
and the ADC. We are not concerned with these two. They are not going to take the money.
So there was-
So we cannot initiate contempt against the others.
My lord, 9/12 it was served.
9/12, then in 9/12, it is not 3 months on 2 when you filed the petition. So your petition was premature.
only the acknowledgement.
No, we are dismissing a petition. You filed a petition on 21/2006. Sorry. Dekho. This is an application file.
My lord, only the acknowledgement is not there for 1 and 2. That was said on 23/6. The petitioner somehow forgot to get the acknowledgement from the website, postal website. And after 3 months, my lord, the entire data gets deleted. From the postal website, my lord, the entire data gets deleted. That's the reason we could not obtain the acknowledgement slip. That was served on 23/6. The postal receipt, my lord, has an X on page 25.
Okay. This is an application file alleging willful and deliberate violation to the order dated 10/6/2025, passed in WPC number 3870/2024, whereby the learned coordinate bench of this court had directed all the respondents to jointly and severally pay the amount of rupees 12,05,874 to the petitioner within a period of 3 months from the date of receipt of the certified copy of the said order. Full stop. From the materials on record, it is apparent that the service of the certified copy of the order was served upon the deputy commissioner as well as the additional deputy commissioner. Walpara,
Yes, ma'am.
by hand.
Yes,
By hand. However, as regards the other respondents, service was meted through speed post, by post. This court, however, also takes note of a communication issued by the additional secretary to the government of Assam Home and Political Department, which was issued to the Deputy Registrar, Gauhati High Court on 23/2/2026, wherein it is categorically mentioned that upon receipt of the certified copy of the order dated 10/6/2025 passed by this court in WPC number 3870/2024, the Home and Political Department requested the District Commissioner Gwalpara to furnish the requisite documents for compliance with the said order via the department's letter dated 19/9/2025. However, no response was received from the District Commissioner Gwalpara. It is also mentioned that the expenditure involved was debitable to the head of account 2055 police-00-101 criminal investigation and vigilance -3191 CSRE-028 logistics support to army conducting operation -26 other charges -99 others EE GA Roman 5 for the financial year 2025-26. It is also mentioned in the said communication that payment shall be made from the budget provisions of the ensuing financial year 2026-27 after verification of the bills and submission of the requisite documents by the DC Gwalpara. This court duly takes note of that in the order dated 10/6/2025, the learned coordinate bench had categorically observed that the amount of rupees 12,05,874 was duly admitted by the respondents. And as such, there was a specific direction to make payment within a period of 3 months. The interdepartmental squabbles as regards who is to pay and who is required to provide the documents cannot be a ground to deny or delay the disbursement of the amount to the petitioners. Accordingly, this court fixes this matter again on 5/2026. In the meantime, if the respondents herein jointly and severally do not release the amount of rupees 12,05,874 to the petitioner, this court would be constrained to pass appropriate directions. Mr. M. Bhagavati, as well as Mr. K. Gugoi and Mr. A. Solia, Mr. M. Bhagavati appearing for the respondent number 2. Mr. K. Gugoi appearing for the respondent number, and Mr. A. Solia shall provide the head of account of the Home and Political Department on the next date.
This matter, my lord, Mr. H.K. is appearing, Lordship is on legs, Lordship, and Lordship, in this matter, we have recently received the instruction, Lordship, and we are preparing it, Lordship. Lordship may kindly give us 2 weeks time, Lordship. This comes fast time, Lordship. Otherwise, Lordship, service is complete upon that private respondent, Lordship.
What do you want now?
Lordship, 2 weeks time may be granted, Lordship, to file it.
5 and 6. We're going to file. We have filed. The counsel is appearing on behalf of the private respondent as well as the official respondent 6 for 2 weeks time for filing the affidavit in opposition. So taking into account the above list this matter on 4th of June 2026. In the meantime, all the respondents shall bring on record their stand by filing their affidavits on or before 25th of May 2026. Liberty given to the petitioner to file reply there against. This is the matter for admission on the next date.
Deeply obliged, Lordship.
My lord, similar matter. Order is at page 16. The amount is 11 lakh.
File impleadment petition. We have filed one impleadment petition. That's because Honorable Court directed me on 13th, Lordship. Before that, my incumbent was transferred, Lordship. That's why.
Well, it came to our notice that respondent number 3, the DC has been transferred.
Who?
The DC.
Why do you require the DC? Link has been made. Same order,
Same order.
7/3/2025.
Similar order.
Now, what is your grievance?
My lord, Tamshil, as per my lord, may kindly have the order dated.
Understood, understood. But what is your grievance?
My lord, they are not giving us the money, nor informing
No,
us.
no, you can't get the money.
My lord, they are not informing us also where is the list, name in the list. That is not being informed.
Why you are not informing? You are going to pay as per Tamseral.
That part is there, Lordship, but in this case, Lordship, Honorable Court directed me to, Lordship, not by the contemptor, Lordship. Directed me to, Lordship, appear on behalf of the respondent number 3, Lordship. In the meantime, he is transferred from that.
Concern, Mr. Gugoi, you are the additional senior
Lordship,
government.
I can.
You are to just find out whether you have carried out
List
the
is prepared
verification.
or not.
And if you carried out the verification, it has to be paid as per Tamserali. Tamserali, he may get it after 5 years also. We are not concerned to that extent. Tamserali means that you have to put him in the chronological list. And after that, it will be paid as per his term. Now, what on earth have you not verified what is the amount?
That part I will obtain instruction.
Oh.
Otherwise, in the meantime,
Day
Lordship
after?
may implement that particular.
Why should I? Day after?
Next week, Lordship.
Next. Just verify and give us the detail. Then it will go as per Tamserali.
Otherwise, my lord, it's an admitted amount. His honorable court had taken the stand that it's an admitted amount.
Where?
My lord, page 16, the third paragraph. Having considered the submissions made by the learned counsel of both the parties, I am of the view that the claim of the petition.
Who is appearing for BTC? This is being done by whom? The
The
home.
DC.
Huh?
Home and political.
Home and political. And how Tamserali
Lordship,
applies?
we'll
This
go-
order is wrong, Mr. Counsel.
We'll go by the paragraph.
You are in more difficulty with this. Because Tamsir the home and political do not follow. We do one thing, we implead and make it, these type of matters is very difficult. You have spoiled your case getting an order with Tamsir. I don't give to, for others, home and political is 6 months. Pay.
Always was to give 6 months time.
6 months time you pay within 6 months. But here, it becomes very difficult. You are not never going to get this money. Because they don't have follow Tamsir.
My lord, but this,
Does home and political follow Tamsir? No. BTC follows Tamsir. BTC follows, irrigation follows, and PW. These are the three departments.
but my lord, here is there is also observation that the claim amount, the admitted amount, my lord. by the court.
Claim or what? But if there is a direction that you pay as per Tamsir Ali means when they don't follow the direction is wrong. You were in a hurry to get the order done. Now suffer. Better go to the civil court. This is an application file to implead the present incumbent Deputy District Commissioner Kokrajhar as the respondent number 5 to the accompanying contempt application. First up, taking into account that his presence would be necessary for due compliance to the, for effecting due compliance to the order passed by this court dated 7/3/2025, passed in WPC number 3931/2024. This court impledes Sri, what is his name? Sri Dr. P. Uday Parveen, IS, District Commissioner, impledes the opposite party number 5 to the accompanying petition, accompanying contempt application as the respondent number 5. Full stop. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days, and the registry shall, on the basis thereof, as well as the order passed herein, shall make necessary correction in the cause title and update the same in the CIS. I stands disposed. Main case. Issue notice upon the newly impleaded respondent number 5, returnable by 22nd of June 2026. Steps be taken upon the newly impleaded respondent number 5 by speed post within 3 days. You have spoiled your case.
My lord.
I feel sorry for you.
This case was Respondent 3 has filed their affidavit on 33, Lordship.
This is for admission?
Yes.
Okay. What is this case? Who has filed what?
My lord, he has filed recently affidavit on 33/2026, Lordship. Some time to take extraction. It was the petitioners.
Who is the petitioner?
But the petitioner is the Provident Fund organization. Here the TFS challenged an order passed by the Provident Fund Appellate Tribunal, by which the Appellate Tribunal will not, without interfering with the original order passed under Section 7A, determining the PF liability of the IOC, will not set aside the order passed in review and will not, and remanded the back to the authority for deciding the review petition again. Though will not review against the order passed, will not when appeal against the order passed rejecting review is barred under the statute specifically. So that original order is not set aside. Only the review order is set aside, and the tribunal said you hear the review petition text. The section 8B specifically said, if appeal is not filed, review can be filed. And the appellate, the power for review is all, appeal is also says that the appellate authority.
Let us see the order as to why the impugn order there is 7/9/2018.
That's right.
Where is it?
order, my lord, is at page, starts at page 207.
In view of the above, the impugn orders
Lord.
dated passed by the RFA in the review petition filed by the appellant are set aside and the review petition is remanded back to the concerned area with a direction to consider afresh for conclusively determining the names, numbers, and periods of engagement of the concerned contract laborer by calling for the relevant records regarding so and so parties are concerned.
This requires determination by in a 7A proceeding.
Huh?
This requires determination in a section 7A proceeding, the original.
Who has filed the review?
Review is filed with the IOS.
Oil India Limited has filed the review of it.
Review.
Yes.
Now, what happened to the review?
Also, we have filed our affidavit in opposition. Maybe
Yeah, tell me.
it was case 262. That review was rejected, Lordship, and 262 of our
Yes.
application for review file under so. Please refer to your petition review petition dated so which was received by the undersigned on so. In this regard, your review petition cannot be entertained for the following reasons. The application for review should be filed within a period of 45 days from the date of making of the 7A order in terms of the provision laid down under para 79A of the EPF scheme source. In the instant case, the order under 7A was made on 17/10/2014, whereas your review petition was received on 7/1/2015 after lapse of 82 days. The application for review also is not as per prescribed format as given in form number 9. The variation part of the format has been omitted in your review. It is also to draw your kind attention that the power of reviewing authority is circumscribed by the provision laid down under para 79A of the scheme, and therefore no discretion is left to the undersigned to override the statutory limitation period. Your review petition dated so and so can be rejected. Against the state order, Lordship, we oppose this honorable court. Case 264.
That was original.
Third paragraph, by filing this petition under Article 2.
Okay, it's okay. I read it, page 269.
Yes.
Then,
So, in terms of this honorable court order, Lordship, the review application was heard, and accordingly the same was rejected, and thereafter we filed our appeal.
then,
So, the review application was filed in terms of the this honorable court's order that was taken, and thereafter.
then you filed an appeal
appeal.
against the review order,
Yes, sir.
rejecting the review.
Review.
But you have not filed appeal against the original order.
Yeah.
How can you file appeal against the review order? Mr. Roy, that is your case.
Well, not, though, well, they made a reference to original, but then appellate authority has not interfered with the original order.
That is why,
That-
no, whatever may be, can you file an order against the
That's right,
review
that's
order?
right, that's right.
Appeal.
Both the order was finished. Lordship, may please 207, Lordship,
Page,
case 207.
207.
Read petition.
Of the writ petition.
Yes, 207. What is this?
This appeal has been prepared by All India challenging the order dated 17/10/2014 passed by the respondent one, as well as the order dated 10/6/2015 and 15/6/2000 passed by the respondent in the review petition filed by the appellant.
Appeal has been prepared by the All India challenging the order dated 17/10 passed by the respondent, as well as the orders dated so and so passed by the respondent in review petition.
Yes, sir.
Now, what has happened?
That was
The review order.
In view of the order dated so and so, impugn orders passed in so and so in the review petition filed by ER set aside, and the review petition is remanded back to the Iman with a, what is the reason for setting aside?
because contract.
Discovery appears to me that the fact regarding actual numbers of a year which so and so ought to have been determined conclusively by the concerned year regarding the review petition. This was also not done.
Even the.
This determination also necessary and so and so. So therefore, the order should have been that not only the review orders are set aside, but also the order of 17/1/2024 should have been set aside and directing them to freshly adjudicate. That should have been the order. That could have been order, or the court should have decided 17-10-2022, 14. But the court could not have said, okay, again take up the review. And that is a court conferring a jurisdiction upon somebody to decide a review.
Respondent has also admitted, Lordship, in para 200, page 214. The respondent counsel also admitted that, we however admitted that in the impugn order itself, there is mentioned that the exact date and number of the contextual level could not be conclusively determined. So ultimately findings are.
That is okay. We are not concerned with that. Let us not go deep into this, because here the question is, who is going to adjudicate? Now the question is, you have challenged the review orders as well as the main order, the original order. When you challenge both these orders, the review order could not have been just set aside. The courts ought to have decided 17-1-2014. 17-1, na? 17-10-2014.
17.
Should have decided 17-10-2014. But 17-10-2014 was not decided. So it may be there are two ways. Either let the appellate court decide that. That is the order. And why are you opposing with so many affidavits? Tell me.
No, only affidavit we have filed factual matters.
Yeah, understood. But these facts, why should I go into it? Yes.
We are actually suffering money. We were engaged to the contractor and this is not in dispute also by them, but we are entitled for professional. Now from February 2019.
No. We are concerned with the challenge to the order dated 7-9-2018. My question is to you is this. Being an officer of the court, when there is a challenge to the review order as well as the original order, normally when a review is rejected, the basic fundamental saying review is rejected, the original order comes into the play. Now, the review was rejected. So they should have challenged the original order, but they challenged the original along with the review orders. Now, put the court, say the review orders are wrong, and directed them to again decide the review petition. So what should have been done? You being the performer, I am asking.
The original order, 1710, ought to have been done on merit matter by the appellate tribunal.
That's the
In the provision matter, that the provision is clearly mentioned matter. In case it is done, and the original order is matter.
No, they have challenged the original. Not that thing.
The tribunal, review of tribunal, the tribunal I'm telling, tribunal ought to have gone into that matter.
The tribunal ought to have decided the 17-10-2014 order. So therefore, this is the small issue.
What acts of bidding matter, in the workers. The fact that they are liable to pay, they have get the details. Only the quantum of payment is in dispute. Only the quantum matter. Now, what's technical going on, my lord, we have somebody matter.
You should have filed here, come this side only.
Well,
You have not. You are still this side.
I think this point, that's why I asked my understand which side I should sit.
Now they.
But I think it's counseling from my mental counsel.
That's why in their.
So that is the reason why, when I took up this matter, earlier it was not before me. On 9-3-2026, I said that the matter would require an urgent disposal. So I therefore said that let the matter being appeal proceeding, you want to bring any document which is a part of the appeal proceeding, they are at liberty to file additional plea. So that there is no delay. So this was on 9-3. So let me. Anyway, it is good that you have filed your affidavit. And he is asking for time
But
for the affidavit filed with
because of the fact that
respondent.
the respondent has contended that.
We have the sufferer, man. That's how it is. We have the sufferer.
No, we can bear. The only thing I can do is directing this appellate tribunal, what is the central government industrial tribunal come labor court to decide the same within a limited period of 6 months. This is how we get. Now, whether the central government industrial tribunal come labor court is functioning?
Yes, yes.
Functioning, na? Sure. Heard Mr. P.K. Roy, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr. K. Kolita, K. na? K. Kolita appears on behalf of the Oil India Limited. Mr. B. Chakraborty appears on behalf of the respondent number 2 or 3. 3 under Oil Welders Association. Performer respond number 3. None appears for the performer respond number 2. The petitioners herein have assailed the order dated 7/9/2018 passed by the learned Central Government Industrial Tribunal Des cum Labor Court, Gauhati, in PF Appeal number 6/2017. Full stop. Taking into account the order which this court proposes to pass, this court is of the opinion that the brief facts which led to the filing of the instant petition are that the respondent number 1 during the course of operation engaged many contractors for execution of various works at various locations. Contract labors were engaged by those contractors for execution of such contract works. Such contractors were required to deduct and deposit the PF of those contract laborers along with the employee's contribution, which is later reimbursed by the respondent number 1 company on submission of bills by the contractors. Full stop. It is the case of the petitioners herein, the respondent number 1, that having received frequent complaints regarding irregular or non-deposit of PF subscription of those contract laborers by some of the contractors, the respondent number 1 company, in order to safeguard the interest of the contract laborers, obtained the PF code from the competent authority, and the effective date was fixed by the PF authority as on 1/8/2006. First, the performer respondent number 2 association filed a complaint that 350 or more numbers of contract laborers were yet to be enrolled under the statutory scheme of Provident Fund. Upon receipt of such complaint, the Regional Provident Fund Commissioner Tinsukia initiated an inquiry under Para 26 Capital B of the Employees Provident Fund Scheme 1952, for short, the scheme. Consequently, the Regional Provident Fund Commissioner Tinsukia issued a notice under Section 7A of the scheme of the Employees Provident Fund and Miscellaneous Provisions Act 1952, for short, the Act of 1952. Subsequent thereto, an order was passed on 17/10/2014 under section 7A of the Act of 1952 on consideration of or under the Act of 1952, thereby levying PF dues of rupees 1,67,09,353 upon the respondent number 1 company. First, the respondent number 1 company thereupon preferred an appeal, prepared a review before the where is the review petition? Where is that order 81/2005?
Page 262.
Huh?
Page 260.
The respondent number 1 thereupon preferred a review application
Regional PF Commission.
under section 7 capital B of the Act of 1952 before the Regional Public Provident Fund Commissioner, Tinsukia. On 7/1/2015, on the ground that there was a delay in filing the said review application, and further that the application was not filed in the format as required. By an order dated 8/1/2015, the review application filed by the respondent number 1 was rejected. Being aggrieved, the respondent number 1 filed a petition before this court, which was registered and numbered as WPC number 258/2015. The learned coordinate bench by an order dated 23/1/2015 set aside the said order dated 8/1/2015 and directed the Regional Provident Fund Commissioner, SRO, Tinsukia, to take on board the review petition filed by the respondent number 1 and thereafter decide the same on merit after giving due opportunity of hearing to the necessary parties. Pusto. By the said order dated 23/1/2015, the learned coordinate bench further had set aside the order dated 19/1/2015, passed under section 8F of the Act of 1952. In pursuance thereto, the review petition was taken up by the Regional Provident Fund Commissioner, which is the order? Huh?
195.
Okay, yeah. And by an order dated
10/6/2015.
huh? Dated
10/6/2016, page 197, the order.
No. Order is different. Order is on kindly come. I think it's
There are
page
two orders, sir.
205.
There are two orders. After this, they filed another affidavit, and then subsequently another order was passed.
Where?
Page 200.
The first order is
No. First is no. That is somebody else order. No?
they have
Where is the 10 or yeah. Took up the matter and by an order dated 10/6/2016. The review application was rejected. on the ground that the respondent number 1 failed to produce any new relevant records and also failed to undertake verification of the details of the contractual workers during the last 1 year and last 1 year, 4 months. On the very date, the chief manager, legal of the Oil India Limited submitted an application that the said order dated 10/6/2016 was passed without considering the submission so made by the respondent number 1. Pursuant thereto, the respondent, the Regional Public Provident Fund Commissioner, there's any reason by an order dated 15/6/2016 again upheld the order dated 17/10/2014 and rejected the review application. It is under such circumstances, the respondent number 1 preferred an appeal under section 7 capital I. 7 capital I of the Act of 1952, not only challenging the order dated 17/10/2014, but also the orders dated 10/6/2016 and 15/6/2016, by which the review applications were dismissed. Full stop. The learned appellate authority, that is the Central Government Industrial Tribunal cum Labour Court, Gauhati, by the impugned order dated 7/9/2018, allowed the appeal, thereby setting aside the orders dated 10/6/2016 and 15/6/2016 passed by the Regional Provident Fund Commissioner 1 Gauhati in the review petition, and again remanded the matter back to the, what is this concerned EPF means? Employed again to the regional, again back to the Regional Provident Fund Commissioner with a direction to consider the review petition afresh for conclusively determining the names, numbers, and periods of engagement of the concerned contract laborers by calling for the relevant records regarding names and periods of engagement of the concerned contractual laborers from the concerned contractors. Full stop. The respondent number 1 company was also directed to submit to the concerned EPF authority the names and addresses of the concerned contractors, and the parties were directed to appear before the concerned EPF authority on 8/10/2018. Being agreed by the order dated 7/9/2018, passed by the learned appellate authority in PF appeal number 6/2017, the present writ petition was filed by this court, by the petitioners herein. The record reveals that by an order dated 2/9/2019, notice was issued and the further proceedings pursuant to the order dated 7/9/2018 passed in case number PF appeal number 6/2017 was stayed. The record further revealed that in the meantime, the respondent number 1 as well as the performer respondent number 3 have filed their affidavit in opposition. First, Hey, employee provident fund. 1952. This court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to their respective submissions. The materials on record as already discussed here, the material facts for the purpose of adjudication of the instant petition as discussed already herein above would show that an order was passed by the Regional Provident Fund Commissioner on 17/10/2014, thereby imposing a liability upon the respondent number one. Pursuant thereto, a review was filed under Section 7, capital B of the Act of 1952. The orders which were assailed before the appellate tribunal were not only the original order dated 17/10/2014, but also the orders which were passed thereby rejecting the review application, which were the orders dated 10/6/2016 and 15/6/2016. At this stage, this court finds it very pertinent to take note of the jurisdiction of the appellate tribunal in terms with Section 7I of the Act of 1952. The said section, being relevant, is reproduced hereunder. From a perusal of the aforesaid section, it appears that any person from a perusal of subsection 1 of Section 7, capital I of the Act of 1952, it would show that any person aggrieved by a notification issued by the central government, or an order passed by the central government, or an order under the proviso to subsection 3 or subsection 4 of Section 1 or Section 3 or subsection 1 of Section 7A or Section 7B or Section 7C or Section 14B may prefer an appeal to the tribunal against such notification or order. The said section, however, excludes a challenge to an order passed under Section 7B when the review application is rejected. The same is in consonance with section 7B5 of the Act of 1952, and this very subsection is reproduced herein under. First, taking into account that the review application in the instant case filed by the respondent number 1 was rejected by the orders dated 10/6/2016 and 15/6/2016. The learned appellate authority had no authority or jurisdiction to decide the orders dated 10/6/2016 and 15/6/2016. The learned appellate authority, therefore, ought to have only decided the order dated 17/10/2014, which was the original order, as the same is permissible under section 7(1) of the Act of 1952. However, surprisingly, the learned appellate tribunal have only decided the legality and validity of the orders dated 10/6/2016 and 15/6/2016, which the learned appellate authority had no jurisdiction to exercise. First, under such circumstances, it is therefore the opinion of this court that the impugn order dated 7/8/2000. It is further relevant to observe that the learned appellate tribunal did not decide the original order dated 17/10/2014, which was also the subject matter of challenge. Under such circumstances, it is the opinion of this court that the learned appellate tribunal had failed to exercise the jurisdiction conferred upon it by law and by not deciding the legality or validity of the order dated 17/10/2014 passed by the Regional Public Provident Fund Commissioner, and on the other hand, have exercised the jurisdiction not conferred upon it by law by interfering by deciding the legality and validity of the orders dated 10/6/2016 and 15/6/2016. Accordingly, the impugn order dated 7/8/2018 is required to be interfered with. 7/9 is required to be interfered with. Consequently, the instant writ petition stands disposed of with the following observations and directions. Number 1, the impugn order dated 7/9/2018 is interfered, passed by the learned appellate tribunal, that is, the Central Government Industrial Tribunal cum Labour Court Gauhati, is set aside and quashed. Number 2, the learned appellate authority, that is the learned Central Government Industrial Tribunal cum Labour Court Gauhati, is directed to decide the appeal, being PF Appeal number 6/2017, only to the extent of the legality and validity of the order dated 17/10/2014 passed by the learned Regional Public Provident Fund Commissioner. Number 3, this court have also duly taken note of the submission of Mr. B. Chakraborty, the learned counsel who represents the performer respondent number 3, to the effect that the members of the association for whom he represents have been deprived of the dues. Considering the above, this court directs the learned appellate authority, that is the learned Central Government Industrial Tribunal cum Labour Court Gauhati, to decide the said appeal, being PF Appeal number 6/2017, as expeditiously as possible, and preferably within a period of 6 months from the date the parties appear before the learned appellate tribunal. Or as all the parties are before this court, they are directed to appear before the learned appellate tribunal on 18th of May 2026.
For review proceeding lordship, if lordship fills the PS 163, additional documents were directly to be furnished lordship. So some documents were furnished in the review proceeding lordship. So lordship, if
You know what to do. This court has stopped giving advice. You go file. This is an appeal. Go and file those documents. Why should I mention all these things? You also know 1 year when you are filing appeal. Motor Workers Union.
Your document can take it at like 2 million.
Huh?
I could not prepare yesterday.
Okay. You are also there. Same type matter.
in this case, we have raised maintenance of the replacement.
All right.
Yesterday, we have raised maintenance of replacement. We have filed affidavit, lordship, they have not filed reply. So lordship may take up the maintenance issue.
What is the challenge here?
They challenge the LS deduction of the wages of the their members of the union, trade union. Whereas we have not deducted from them, we have deducted in terms of the contract agreement from the contractors. Contractors were not made as a party respondent in the instant proceeding. And during the proceeding, pendency of the disrequisition lordship, already MOS was executed between the Oil India Limited as well as the members of the trade union. Wherein the clause
Mr. A. Das Gupta, the learned senior counsel appearing on behalf of the petitioner, submits that he is not prepared today and as such seeks for an accommodation. List this matter again on, there's no stay, na? On 1st of June 2026. On which date the question, on 2nd of June 2026, on which date this court shall decide as to the maintainability of the take up the issue of the maintainability of the Yes, what is it?
Your lordship, here I was to supply some roll bandage.
Huh?
Roll bandage.
Roll bandage. Okay,
Now,
then-
the tender NIT has prescribed certain specification. I was directed to strictly comply with it. I have supplied it. There's no complaint that I have not complied with that specification. Subsequently, so-calls have been issued saying that I have contravened the provision of the Drugs and Cosmetic Act, the specification prescribed in F2. My contention is this, that NIT having prescribed a specification and I've been required to comply with it strictly. How can I be,
Has the final decision been taken?
they have issued a show cause, I've given it, and thereafter no coercive action was.
Huh?
Lordship, if it is possible and not to inconvenient, can this matter be taken up as separate? Lordship, V. Goga knows this matter more than me. That's why. He'll be able to appraise this court better.
Health.
It would be NHM in this case, Lordship. National Health Mission.
The council for the health is not ready. Who are you? Why you have made everybody a party?
Because the notices were issued to everyone with copies.
Let's see the so-called. Can we
That's your
discuss?
lordship, fine. At page 114.
114. Within 15. This one,
Yes, sir.
so-called notice on declaration of mark of standard quality so and so. As per the tender clause, if any item supplied has been partially or wholly used or consumed of the supply are subsequently found to be inferior quality. Please noted that as per the tender clause number so and so. Your reply, what is the allegation?
The allegation is that I have not that the supplied roll bandits are not of the standard quality.
Where is that?
That your lordship will see at page 118.
Huh?
118,
No, so cause is 114.
20. What's Annexure 10 is the findings.
No, where is the so cause?
So cause is that 114.
Where is it mentioned? On receipt of the report from the government or so and so, so and so, so and so.
Yeah, you have to.
A so cause that shall be issued to the supplier
receipt of
calling
the
for
report from the
explanation within so
115.
and so on receipt of the. Now, where is the allegation that it is inferior quality? It is noted that as per the clause number so and so. They are only putting clauses.
Yes, your lordship.
Where's the allegation?
No further supplies accepted from Tindus.
Then another allegation is there. Same.
118 is the ground on which they are saying.
Huh?
118 is the ground. The report actually.
How can one read 180? You
Because
read,
there,
you do,
like
Mr. D. Senapati, you do one thing. Take this quote.
No,
No.
119 is there.
No,
Your lordship.
no.
119
You
is the
read
type
this
copy.
file. You read it and give me that tab. You read it. You read it from there.
Yeah,
I will
119
allow
is the
your
type
petition.
copy, your
No,
lordship.
I will allow your petition. Read it from there. You don't give me the second copy. And you argue from that. Read it. No, read it.
Okay. It is certified that report of test or evaluation of medical device by medical device testing officer. It is certified that the sample having serial number of memorandum of receipt under CTS CDO Gauhati sampling.
So this is the allegation.
The allegation here.
Now this is the allegation.
Yes.
It is not readable. So we dismiss your petition. Now give me the file for dictating the order. Division bench, you have very kind judges, they will help you.
119 is the type.
No. What 109?
Is the type copy of that report.
Difficult to read. It is difficult to read. You can't read 115, 114 also. These are underlined and you have typed out, not typed out these. How can people read it? These are all above you. Once you highlight it and then you print out, this is how I'm reading it. Mr. Bhuya, read 118. Can you read it?
Yes, Lord. It's
Read it.
here. Yes, Lord.
Good.
Lord,
Read it.
it is certified that the samples having serial number of memorandum or receipt number so and so, dated so and so, purporting to be sample of roll bandage batch number so and so, manufactured by the petitioner hearing bearing sample number so and so, received on 9/2/2022 from so and so, has been tested or evaluated, and the results of test or evaluation is as stated below. The conditions of seal on the packet or on portion of sample or container were as follows. The
And
sample
where is the so-called reply?
132.
Our explanation to the so-called. Now what has happened? Why have you approached this court?
I have approached this court because my condition is that in terms of the NIT, the specification for which was required to supply is considerably different and distinct from this specification on which you have conducted the test.
Why should we look into it? Go there. After any order, why should I initiate this court at all entertain this type of requisition? Suppose you have given, let it be there decided. After the decision, we'll look into it.
Because the controller of drugs has caused a prejudice because he's already deciding my goods in terms of F2. That is not the NIT stipulation. NIT stipulation says 100 gram per dozen. F2 comes to 285 gram per dozen. So if the controller, whom do I go to? The National Highway Authority, the Health Mission. It's already taking a decision. They're not going to independently decide my case.
Where is Mr. Big Boy?
Lordship, he is on legs in court number 1. But however, Lordship may peruse paragraph 5, 6, 7, and 8 of our affidavit in opposition, starting from page number 181, running page number. That would be most relevant.
When was the so cause notice issued?
13-4.
Huh?
34.
Huh?
32.
13 to 2022. Then you submitted your reply on? There is another one on 13/6 or something.
Yes, there are two show cause.
What is the second date?
18-6.
18/6/2020.
18/6/2022. And your reply?
19/4/2022 and
19/4/2020.
22/6/2024.
Then they send it to the some laboratory.
No, thereafter, since we raised that objection.
They send it to the laboratory.
The clarification is given at page 121.
No. The laboratory it was sent to technical feedback on 10/5/2022. Isn't it?
Yes,
10/5/2022 it was sent. Then they give a report on 24/8/2022. And then they ask you to do something at page annexure 2, page 189. This is to inform you that against your explanation in respect to the issued show cause notice on Iman, so and so you requested submission of the technical feedback. Accordingly, they have given their feedback on the matter which is attached, so that you are hereby informed to take necessary on the NSQ declared batches of so and so, as per the tender clause immediately. What happened thereafter? What remains in the instant repetition thereafter?
August 24.
No, I'm not on that. You see, they issue a show cause. You submit a reply on 19/4, saying that this has to be done as per F2 schedule or something like that.
Okay, the case is that it cannot be done as well.
Whatever may be, you say some ABCD. They say, okay, we are not in a position to look into the ABCD. They refer the matter to a particular authority. Authority gives a joint investigation report on 24/8/2022.
Right.
And then that joint investigation report is forwarded to you on 4/11/2022. Now, why?
That also has been challenged.
Why?
Because my submission is very simple. That here the explanation that they are giving that my product will be governed by F2 is
No, I'm not concerned with that. Why are you challenging 4/11?
I'm challenging 4/11 because the justification assigned for doing the testing in terms of schedule F2.
How do we know?
Then I don't have a forum.
You don't have a forum, that is your lookout. We are not here to
Because
decide.
your lordship, the first thing. that
We
your
are not
lordship will-
expertise. No, we are not expertise. Here they have given a justification how it is to be done.
But these
Then
justifications.
how do you say, what do you say about this 4/11? What is wrong with 4/11? What do you say about the joint inspection report, what the investigation report? What is wrong with that?
Your lordship will just see one instance. Your lordship.
This court cannot look into
4/11
this.
is, nothing is much given.
No, 4/11, no. 4/11 is nothing given. 4/11 is the most important document. 4/11 says that you are required now to do so you are hereby informed to take necessary action on the NSQ declared batches of both area as per the tender clause immediately.
That is basically taking it back.
Whatever may be.
That has been, but your lordship, the explanation that they are providing, that why it comes under the F2. In my humble submission, your lordship.
No. Why they come under not? We don't have the expertise.
No, your lordship.
No.
do not have the expertise to look
Mr.
into it,
Counsel,
but your
no,
lordship will-
sorry.
your
Kindly
lordship
see,
will-
the joint investigation report which is being given, if there's something is wrong out there, we don't have the expertise. They have given this report and
No,
you have to give.
Your lordship may just hear me.
Kindly
from
come to, no, kindly come to page 194.
190.
We are not going to look into all that. stability data not provided by the firm for the said period product as claimed shelf-life for 3 years. The firm has not performed the test as per the requirement of the signed Schedule F2 for the said product. Firm has not provided the details of the approved vendor of procurement of raw material. Firm has not maintained the topo logbook for the various instrument machines used for the year. The area provided for the storage of so-and-so. The waste, the pest control records and approved items are stored in dampness. Firm is not provided the dedicated areas for storage of the finished, labels, temperature, and humidity not controlled and monitored. So-and-so calibration status of the machines are not found maintained. This is the report. So on the basis of this report, now kindly see the remarks at page 195. On the basis of the above investigation and documents produced by the firm and facilities visited, the undersigned officers are in opinion that the firm has manufactured products as per MR tested third party released for distribution as per SOP and sold the impugned product so-and-so expiry dated. Hence, based on the above invented observation and the test report issued by Director AIA, the investigating team is of the opinion that required necessary action may be taken against the firm by the state so-and-so under so-and-so on the same drugs declared not of standard quality as well as so-and-so. Now have you challenged this report?
Your Lordship, after this,
Have you challenged this report?
Your Lordship, just here, after this, there was a debarment order that was passed. That debarment order has been revoked by them, saying that the Drugs and Cosmetic Act will not be applicable because I have obtained license under the Medical Device Act. That I have brought it in terms of the additional affidavit.
What additional affidavit?
There's
Rejoinder.
an additional affidavit, Your Lordship.
Rejoinder. Oh, additional affidavit. What is that?
Your Lordship, may just see page 222. In person to that investigation, the basis of that investigation, they debarred me.
For 5 years.
Yes,
Then
that has been revoked at page 227.
so
So my contention is that if I am governed by the Medical Device Act.
no. You have now obtained later. So
Then
now
that
the
action
question is you have already been debarred.
I was debarred, it was revoked. I am now in the stance
So
of
therefore, what remains in those so-called proceedings?
the so-called process is with regard to the roll bandage. The roll bandage, if they are saying of the substandard quality, in that eventuality, I will not even be paid. Now, my case is this, that you prescribe a specification. I strictly comply with that specification. Can you be permitted to do a testing in terms of a specification which is not a part of the NIT?
But you have not challenged this joint inspection.
That has already been revoked because that was
No,
the basis
that
of
has
the,
not been revoked.
the show-cause were issued on the basis of, your Lordship may also say, on the basis of the report at page 118.
So what remains after, you see, kindly come to page 213, that is the joint inspection report. The debarment notice.
No, if they are not contemplating any action in pursuance to the show cause, then I have no case. But
No,
if they are
no.
saying that. my
Wait.
needs
Don't read your word. I'm asking you, you have issued the show cause on 13-2.
13 plus.
Then another on 18-6,
18-6.
saying that the role is bad.
Lordship,
He replies,
Lordship,
you carry out an inspection,
Lordship.
but particular inspection, the investigation you carry out. That on 4/11 you provide the inspection.
Lordship,
You give it to him and kindly do the needful as per that.
Lordship.
Now thereupon you take action for debarment on 29/4/2023.
23.
Okay.
Lordship,
Now these debarment, kindly come to page 213.
213. Yes, Lordship.
Kindly see the reference number 3. mail received from so and so subzone regarding the joint infection of so and so. Control letter dated so and so 2/9/2022. Isn't it? Now your company Anamika was under the RC contract of so and so, so and so, so and so. Your company has agreed all the terms of the tender and submitted Annexure 15 against the tender. You have submitted Annexure 2 along with the declaration that if any information furnished by you is proved to be false, then you will be debarred. In this context, it is to be mentioned that so and so had shared the joint inspection report of your manufacturing unit, wherein adverse reports have been highlighted with respect to your manufacturing facility, and it's clearly established that you have submitted wrong false statement about so and so. Thus, as per Annexure 2 so and Annexure so and so declaration submitted by you, therefore your company is blacklisted from all tenders so and so for a period of 5 years. So this is what you do in pursuance to that SOCOS.
Lordship.
Initial SOCOS.
Initial 13.
Okay, 13.2. Now, then they give a declaration that after the debarment, they take a certificate.
Lordship.
Kindly see the certificate. They must have given something. This is 7/12/2024. After 1 year. Page 227.
227.
Although the debarment was for with reference to the subject cited above and the letter referred to above. This I don't know. What letter is this? It is to inform you that since Anamika has submitted representation on 28/11 in March, that they have now obtained the new manufacturer's license and the Medical Device Act under the Medical Devices Act so and so. After the issuance of the debarment order dated so and so, the debarment order dated is hereby revoked. Meaning thereby, the actions which you have taken finally pursuant to your so-called notice is now revoked.
Lordship.
Now, if it is revoked, what remains in the proceeding?
Understood, Lordship. Yes, sir. I understood the point.
Where is this, your representation dated 28/11?
8/11.
Take out the 28/11. I'm coming in 5 minutes. And ask Mr. P. Gogoi to come.
Lordship.
Yes.
Lordship, I'm just picking up.
So there is nothing remains.
Lordship. Debarment order, Lordship, it has already been revoked, as your Lordship has rightly pointed out. Aside from that,
You initiated the proceeding for debarment.
Lordship. It has been,
That is the subject matter of challenge.
Lordship.
Thereupon, debarment notice has been passed
Lordship.
and there has been revoked.
Lordship.
So if it is now being revoked, what remains in the original proceeding? Now, this document is important, which he has not included. Mr. Gugoi, tell me, yeah, you initiated the proposal, the proceedings by way of two so-called notices.
Two so-called, yes, ma'am.
One is on 13/2 and one is on
18/6.
18/6. He submitted a reply on 19/4. Thereupon, you send it to the my assistant back controller or something to the effect. They made an investigation and came up with a report that it was not of quality. Thereupon, you sent that report to them
Yes.
by 4/11.
My lord.
And thereafter, you debarred him.
My lord.
Once you debarred him on 29, you debarred him on a particular date. What do you call it? 29/4/2023.
My lord.
Thereupon,
My lord.
they submitted a particular document, representation, on 28/11/2024.
Lordship.
This is the representation. Can you see this? This is very relevant because why they have requested, they admit. Can you see the language also? We would like to bring to your kind knowledge that a farm was debarred by your organization on the basis of inspection reports submitted by SITSCO and for not meeting us, our declaration of facts submitted by us.
My lord.
In this reference, we have informed you earlier that the inspection was done without prior information and we were renovating the factory premises for and as per the Medical Devices Act 2017. And our drug license was expiring on 31/12/2022. And hence, to continue business, we have to prepare our factory for the Medical Device Act. Now we have got the medical license, new license,
My lord.
as per the Medical Device Act, and after full inspection by the relevant authority, copy of the license is attached. Hence, in view of the new development, we request you to cancel our debarment.
My lord.
And accordingly, the debarment was cancelled by a communication dated 7/12/2024. So therefore, what remains in the original proceeding?
There are two issues, my lord. So far as the, my lord, present writ petition is concerned, it's not related to this debarment. This is a debarment which was issued after, my lord, there was a physical verification in the factory,
Understood.
not regarding supply of product. This entire is batch of today's writ petition, my lord, before the honorable court, is regarding supply that they made to us. That's a separate issue, my lord, regarding factory part. These particular notices were issued on the basis of the report we have received from the central agency of the bandages that they have supplied to us as per their contract. And, my lord, that particular entity, authority of central government who has issued those, my lord, reports, negative reports against them, they are not a party in the writ petition, my lord. Neither the report has been put to challenge, nor those authorities are.
No, understood.
And this part is different, my lord. Factory part is totally different.
No,
Not connected to this.
I understand. That is a different aspect.
Yes.
Not from that.
Yes, sir.
That is why I brought this document
Yes, sir.
from them, which they have not enclosed. You said that in pursuance to a tender, they supplied certain goods.
Yes.
When it was tested, you found that it was not of standard quality.
The report from the central authority.
No, initially,
My lord.
not of standard quality.
My lord.
Then they say that you could not have done it as per F2.
Yes. Yes. Yes.
Yes. This, therefore, instead of doing by yourself, you sent it to the central drugs level.
Being the expert, my lord, in the field.
Yeah, they came up with a report and gave the report out there to the effect that yes, this was not of standard quality.
They explain, my lord.
This report was forwarded to him by 4/11/2022. Now, after that, you debarred him.
No, not on this point, my lord. There is a stay probably in operating in this writ petition, so we could not proceed beyond, my lord, 4/11. In the writ petition, some protection was given. No coercive action. So on this point, my lord, we have not proceeded further.
No coercive action for what?
Well, against this so-called, my lord, last one, where we have submitted the
report of the authority and their clarification, subsequent clarification.
But this order which was passed on 22/3/2023.
Well,
In this connection, a so cause notice have been issued on 9/13/2, which the petitioner claims to have replied. However, no final decision has been taken till now. This is the order.
yes.
And where there is the interim order?
Well, yes, there is some protection, my lord, given, but that's why we have not proceeded, my
No
lord.
final decision be taken without the leave of the court.
So it has not been taken. So this is a subsequent action, factory part.
No,
This
no,
has
no,
been-
no, understood. Understood.
So we have not proceeded, my lord. Why I'm saying is, my lord, whatever now they want to justify that it will not come under a particular schedule. But that examination has been made by the central agency. We have provided them with the report. We have provided them whatever reply they have submitted against their reply. Despite that, my lord, they are not a party to the present proceeding. And my lord, these particular reports have not been put to challenge. They are trying to justify it before the honorable court without making a challenge to those reports. Being the experts, my lord. Lordship will see, my lord, for a moment, so Lordship will see the respondents. Entire, my lord, almost, my lord, every drug authority of the country, my lord, are party in the petition. I don't know why they made from Mumbai, Tripura, Ghaziabad, Chennai, everybody is there. But the authority who has, my lord, who gave the negative report, they are not a party in the report. They are the one who will have to, my lord, clarify whether it is under this particular schedule or not. First, you will see, my lord, page 7 for a moment now. Or 8, my lord. Why they have made, my lord, I don't know, from A 5 or 6. My lord. Drug controller Manipur, drug controller Mizoram, drug controller Nagaland, drug controller, my lord, Tripura, then Mumbai, Ghaziabad, Chennai, Kolkata, Hyderabad, Ahmedabad, Bangalore, Baddi, Indore, Jammu, Goa, everything. Main party is not there, my lord, who has declared that they are good should not have standard. Despite providing them with the information as well as the report that this is the authority who has provided it, and we are bound by that report. And as per the terms and conditions, we are issuing the
Now,
status.
tell me why the debarment notice was issued.
My lord, there is a separate proceeding, my lord. They visited the factory. And that was sorted out in the departmental level itself. When they submitted this representation, it was removed, that department. That's a separate proceeding
No, kindly,
altogether.
no, kindly come to this, kindly come to page 213.
My lord. Yes. 213.
This is the debarment.
Yes. Lordship will see, my lord, the third para, page 213. In this context, it is to be mentioned that CD's SCO, Subzone Gauhati, has shared the joint inspection report of your manufacturing unit conducted by so-and-so North Zone, Government of India, Drug Controller UP. So that's a separate, my lord, inspection that was conducted along with the, my lord, authorities of UP, where the factory
So
is
this
located.
has nothing to
Do in
do
the
with
present case. Because
So
we have
this
not proceeded
debarment is because of the inspection being
in
carried
the
out and
factory,
it was
factory
found not to
premises,
be
a
improper.
totally different, my lord, aspect, and it was already sorted out. But this week it could not continue because of the interim protection given by the owner. And the tender, that tenure was sometime in 2021. It's already over. Other, but we will see, my lord, that part of
But he may not have received the money.
that part, of course, yes, the payment and all will permit this. But without that authority, my lord, perhaps, my lord, to take
No,
the.
first of all, this court doesn't have the
That's
expertise.
why I'm saying, they should have been made a party, they would have, my lord, contested. Now they are trying to explain.
Respondent number 8 is the part.
Oh, the concerned authority who have issued. The government of India, my lord. So we will see the reports and all. Assistant Drug Controller India. So that response will have to come from that authority.
Who has the service being effective?
Some where, sir? No, report. Nobody has appeared. No, they will. Some.
Huh?
They will have to respond. We are pending on the report.
Has the service been effective upon the air? Have you initiated the central government made a party?
Yes, otherwise the party respondent four, I suppose, so. Respondent four.
Name of so and so is being shown.
My lord, lordship will say order dated 22/2/2023.
Or name of so and so has not been shown.
Here, go back to the.
If the central government is the AR, then AR, let us see how notice is going.
22/2023.
CKS Bulwa is appearing for response number 4.
Probably, my lord, their names are not reflected. I have also not found it.
But there is no interim order here. Interim order was passed on, last interim order was passed on 2/5/2023. Interim order.
No final decision. No final decision.
No. 2/5/2023. Interim order to continue till the next day.
That part,
Thereafter, there is no interim order.
not, no continuation.
Not a single order passed whereby it say that the interim order will come. No, I think you take a decision. We are not going to interfere now. Let it be decided thereafter, let him come up before his court, if he's agreed, let him come up and all these things. And they will also duly consider his debarment and removal shall also be considered at that point of time by the
That we
authority
can
concerned. Nothing. Why should we decide all these things?
And dispute redressal clause is there in the contract. Otherwise, alternative remedy was there in the contract.
No, it's there. So you have issued a SOP. He has replied. Thereafter, you send it to that some SITSCO. SITSCO give a report. On the basis of that report, you forward it to him. Thereafter, he had challenged these three before this court. So let the authority decide whatever it is. And by giving him a personal hearing, and he will do whatever he let Mr. D. Sonapati, instead of arguing here, do they?
Just one aspect.
Nothing.
The mission director is the authority. Now, the mission director has already filed an affidavit expressing his view.
So
There has to be some other independent.
No. that cannot be because of the fact that you have initiated a SOCON. That is why normally when a SOCON notice is issued, the court normally do not decide, do not entertain, because you will be asking him to give a reply. Why should I look into it?
Unless there is a plea that it is without jurisdiction.
Huh?
Unless there is a plea that it is without jurisdiction, it doesn't mean.
Why should I? Now, heard Mr. T. Senapati, the learned counsel appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the
State respondent.
respondent numbers 1, 2, and 3. Ms. P. Agarwal appears on behalf of the respondent number 7. None has appeared on behalf of the other respondents. The petitioner herein have essayed The two show cause notices which were issued on 13/2/2022 and 18/6/2022, as well as the communication dated 4/11/2022 before this court by the present petition. The brief facts which led to the filing of the instant writ petition are that in pursuance to an e-tender issued by the Mission Director, National Health Mission Assam, calling for bids from empanelment for entering into rate contract come empanelment of manufacturers to supply of essential surgical consumables and chemicals. The petitioner participated in the said tender proceedings. The said tender proceedings contained various terms and conditions. Clause 22 of the said notice inviting tender stipulated the quality testing Clause 25 related to quality control, deduction and other penalties. Taking into account the relevance to Clause 25, subclauses capital A, capital B, and capital C of Clause 25 are reproduced hereunder, page 49. The same tender also stipulated the items with quantities at Annexure Roman 13. The items at serial number 35 and 36 are relevant, taking into account that it relates to roll bandage 10 cm into 5 meters, 100 gram per dose, and roll bandage 5 cm into 5 meters, 60 gram per dose per dozen. The petitioner, in pursuance to this notice inviting tender, was empaneled as a subsequent thereto, supply orders were issued to the petitioner. For roll bandage 5 centimeter into 5 meters and roll bandage 10 centimeter into 5 meters. To be delivered at various delivery destinations. The petitioner supplied these roll bandages. However, upon testing these roll bandages, it was found by the various test reports submitted by the Standard Analytical Laboratory and bracket ND Private Limited. Subsequent to the supply of the said roll bandages, it was found upon testing carried out by the Central Drugs Laboratory, Government of India, Kolkata, in their report dated 23/3/2022 and 10/6/2022, that the said roll bandages so supplied by the petitioner were not of standard quality. And remarks were given in the test report that a sample You see, kindly come to page 118. That is why you have placed this in such a matter, because 120 is different.
One of it is psychological type. It does not conform. Sample does not conform.
That a sample does not conform to Schedule F2 in respect of test for threads per DM. Further to that, it was mentioned that the weight in gram/meter square, comma, foreign matter and fluorescence. It will account 818. And the reason for declaring the sample as not of standard quality were inverted comma. The sample does not conform to a Schedule F Roman 2. Itu apni style ho, page 118 hours. We will take the Similarly, under such circumstances, the petitioner was issued a show cause notice on 13/2/2022 on the basis of the said report dated 23/3/2022. And again, another notice was issued, a show cause notice on the basis of the report dated 23/3/2022 in respect to the item roll bandage 5 centimeter. Similarly, in respect to the roll bandage 10 centimeter into 5 meters, the petitioner was issued another show cause notice dated 18/6/2022, again based upon another report dated 10/6/2022, provided by the Central Drugs Laboratory, Government of India. These two show cause notices are the subject matter of challenge before the present proceedings. Pursuant thereto, the petitioner had submitted a reply to the said show cause notice online, or reply to the show cause notice dated 13/2/2022 on 19/4/2022. In the said reply, which is Annexure 14 to the writ petition, it is mentioned that while the laboratory tested the material, that is roll bandage as per Schedule Roman 2 of the Drugs and Cosmetics Act, which is not, the said test is not applicable in the case of the petitioner, inasmuch as the testing protocol was not followed as per the tender condition, but was followed as per the Schedule F2 condition. It was further mentioned that the materials so supplied by the petitioner as per the tender condition, and the petitioner and the respondents could check it with the testing protocol mentioned in the test certificate, bracket weight, length, and weight point. A similar reply was also issued to the show cause notice dated 18/6/2022 by the petitioner on 22/6/2022. The records further reveal that in pursuance thereto, the respondent number 2 made a request to the Assistant Drug Controller India, Ministry of Health and Family Welfare, that is the respondent number 4, by the communication dated 10/5/2022. Thereby seeking a technical feedback. The respondent number 4 thereupon sought for a joint inspection to be carried out. By the communication dated 29/6/2022, investigation to be carried out. By the communication dated 29/6/2022 to the Drug Controller of India. A joint investigation report was prepared. By the committee so set up. And the deputy and the state inspection investigation reports mention that necessary action may be taken against the petitioner firm by the state licensing authority under the provisions of the Drugs and Cosmetics Act 1940 and the rules thereunder on the sample of the drug declared, inverted comma, not of standard quality, as well as the anomalies found during the inspection / investigation of the firm. This report is dated 24/8/2022. Interestingly, the said report is not challenged in the instant proceedings. The said report thereupon was forwarded to the respondent number 4 by the Deputy Drug Controller, India, by the communication dated 2/9/2022. Upon receipt of the said report, dated 24/8/2022, the additional managing director of the Assam Medical Services Corporation Limited issued a communication dated 4/11/2022 to the petitioner to take necessary action on NSQ declared batches of roll bandages 5 cm and roll bandages 10 cm as per the tender clause immediately. This communication dated 4/11/2022 has further been assailed in the instant proceedings. The instant petition was filed on 9/2/2023. And this court, by an order dated 22/2/2023, while issuing notice, duly took into account that there was a show cause notice issued on 13/2/2022 and the petitioner had replied on 19/4/2022. Observe that no final decision be taken without taking the leave of the court. The interim order was thereupon extended from time to time. However, post 7/2/2024, till date, the said interim order have not been extended by this court. In the meantime, pursuant to the issuance of notice the respondent number 2 had filed an affidavit in opposition justifying their reason for initiation of the said show cause proceedings. That is, issuance of the show cause notices dated 13/2/2022 and 18/6/2022, as well as the letter dated 4/11/2022. The respondent number 3 had also filed an affidavit in opposition. Again, justifying the initiation of show cause proceedings against the petitioner. Petitioner had filed a rejoinder affidavit It is also interesting to take note of an additional affidavit filed by the petitioner on 26/11/2025, wherein the petitioner enclosed the debarment notice issued to the petitioner for 5 years due to furnishing false information about the manufacturing facilities by an order dated 29/4/2023. The said debarment notice, however, a perusal of the said debarment notice, however, would show that the said debarment notice was issued on the basis of an inspection being carried out by the CDSCO, North Zone, Ministry of Health and Family Welfare, Government of India, on 2/9/2022. And the adverse report so given as regards the manufacturing facility of the petitioner. It is, however, relevant to take note of that in the said additional affidavit, the petitioner have enclosed a communication issued by the Managing Director of the Assam Medical Services Corporation Limited, dated 7/12/2024, whereby the debarment order dated 29/4/2023 was revoked on the ground that post the debarment notice dated 29/4/2023, the petitioner had obtained the new manufacturer's license under the Medical Services Act 2017. First, during the course of hearing, this court inquired with the learned counsel appearing on behalf of the petitioner as to the letter which was issued by the petitioner, which led to the withdrawal of the debarment order dated 29/4/2023. During the course of the hearing, the learned counsel appearing on behalf of the petitioner had produced the communication dated 28/11/2024, which was issued to the Managing Director of the Assam Medical Supplies Corporation Limited. The said document, being relevant, is kept on record and marked with the letter X. In the above, in the backdrop of the above factual aspects, factual scenario, factual details, this court have also heard the learned counsel appearing on behalf of the parties. Mr. D. Senabati, the learned counsel appearing on behalf of the petitioner, submitted that The instant petition has been initiated, challenging the way show cause notice on the ground that the said show cause notice was based upon a report, upon test reports submitted by the CTC Kolkata. And the test reports which were carried out were not in consonance with the protocol of the tests which were to be carried out. Mr. B. Gugoi, the learned counsel for the petitioner therefore submitted that under such circumstances that the very initiation, the very show cause notices which have been issued is nothing but an abuse of the process for which the same are required to be interfered with by in exercise of the jurisdiction under Article 2 to 6 of the Constitution. The learned counsel appearing on behalf of the petitioner further submitted that in the meantime, there was a debarment order dated 29/4/2023, which have been recalled by the managing director of the AMS of the Assam Medical Service Corporation Limited on 7/12/2024, after the petitioner had obtained the medical service license under the Medical Device Act 2017. The learned counsel submitted that as the petitioner has a license under the Medical Device Act 2017, the test protocol therefore so followed, which led to the issuance of the show cause notices being not in consonance with law, and more particularly when the Drugs and Cosmetics Act 1940 would not be applicable. The instant proceedings, the show cause proceedings are required to be interfered with. Mr. B. Gugoi, the learned counsel appearing on behalf of the respondents numbers 1, 2, and 3, however, submitted that the debarment of the petitioner by the order dated 29/4/2023 is a completely separate matter from the initiation of show cause proceedings, inasmuch as the initiation of the show cause proceedings is on account of supplying roll bandages by the petitioner of inferior quality, whereas the debarment order was passed on the ground that while carrying out the inspection, it was found that the manufacturing unit, it was found that false informations were furnished by the petitioner as regards the manufacturing facilities. The learned counsel appearing on behalf of the petitioner, further respondent numbers 1, 2, and 3 further submitted that the very document which is kept on record and marked with the letter X clearly shows that the petitioners duly admit that their manufacturing facilities was not in order at the time of carrying out the inspection, and subsequently the manufacturing facilities were made good, and in pursuance to such manufacturing facilities being made up to date, and inspections being carried out, a license was issued in Form MD5 in terms with the Medical Device Act 2017. The Learned Counsel submitted that subsequent thereto, as the petitioner have improved their manufacturing facilities, the debarment notice order dated 29/4/2023 was revoked by the order dated 7/12/2024. The Learned Counsel for the respondent therefore submitted that the withdrawal of the debarment notice order by the order dated 7/12/2024 is a completely separate aspect which have no relation to the present dispute. The Learned Counsel for the petitioner, respondent numbers 1, 2, and 3 further submitted that the so-called notices were issued to the petitioner on the basis of certain test reports provided by the CDC, Kolkata. The said test reports have not been put to challenge. The petitioner thereupon submitted that the tests were not conducted as per the test protocol. And it is under such circumstances the respondent authorities have placed the matter before the respondent number 4. And the respondent number 4, through the Drug Controller India, have caused an investigation to be made, and a report was then also submitted on 24/8/2022, opining that the materials so supplied by the petitioner were not of standard quality. The Learned Counsel for the petition, respondent numbers 1, 2, and 3 therefore submitted that this very joint investigation report was given to the petitioner on 4/11/2022, and the petitioner have not cared to challenge the said report also, joint investigation report. First, the Learned Counsel, Mr. B. Gogoi, the Learned Counsel further submitted that in addition to that, this court submitted that as these so-called notices have been issued on the basis of reports being submitted by experts, this court may not like to interfere. That too, when there is no challenge to the test reports, by exercising the jurisdiction under Article 2 to 6 of the Constitution. Let me come back. I put your submission. Your submission is this, na?
Yes, sir.
I put all your. This court have heard the Learned Counsels appearing on behalf of the parties and have also taken note of the respective submissions. The challenge made in the instant proceedings are to the show cause notices dated 13/2/2022 and 18/6/2022, was issued by the managing director of the Assam Medical Supplies Corporation Limited. These two show cause notices were issued on the basis of certain test reports submitted by the Central Drugs Laboratory, Government of India, Kolkata, dated 23/3/2022 and 10/6/2022. These two test reports have not been put to challenge before this court. Be that as it may, the petitioners thereupon had submitted a reply on 19/4/2022. And in the said reply, the petitioner have urged that the procedure followed in carrying out the tests were not as per the test protocol. The respondents, the concerned respondents, thereupon sought for a investigation, sought for technical feedback from the drug controller, India, by the communication dated 28/5/2022. Thereupon, have sought for a year from the respondent number 4 by the communication dated 28/5/2022. The drug controller, the respondent number 4, thereupon sought for a joint investigation from the drug controller, India, by the communication dated 29/6/2022. And in pursuance thereto, a joint investigation was carried out by the committee set up by the drug controller, India, and a report was submitted on 24/8/2022. Wherein also it was held that the materials so supplied were not of standard quality. This report was forwarded to the petitioner by the communication dated 4/11/2022. Thereupon, the petitioner had approached this court by filing the present petition. The question therefore arises as to whether it is pertinent to mention that the report of the joint investigation dated 24/8/2022 is also not on challenge. Under such circumstances, the question arises as to whether this court should exercise the jurisdiction under Article 2 to 6 of the Constitution in respect to the initiation of the so-called proceedings by the Managing Director of the Assam Medical Service Corporation Limited. It is well settled that normally the writ court should not interfere at the stage of issuance of a show cause notice by the authorities. Inasmuch as by issuance of a show cause notice, parties gets ample opportunity to put forth their contention before the authorities concerned and to satisfy the authorities concerned about the absence of a case for proceeding against the person against whom the show cause notice have been issued. The reason for not interference with the show cause proceedings is in order to relegate the parties to the proceedings before the authorities concerned is always considered to be the normal rule. Be it as it may, there are exceptions to the exercise of jurisdiction under Article 2 to 6 in respect to a challenge to a show cause proceedings. They are either when the such show cause notice is issued by an authority without jurisdiction, or when such issuance of show cause notice is an abuse of the process of law. In such exceptional circumstances, the writ court would not hesitate to interfere even at the stage of issuance of a show cause notice. It is also very pertinent to mention that mere assertion by the writ petitioner that the notice is without jurisdiction and or abuse of the process of law would not suffice. It has to be prima facie established thereby whereby this court, the writ court, can consider that there is no necessity for any factual adjudication. In the backdrop of the aforesaid principle of law, this court would like to deal with the facts It is not the case of the petitioner that the managing director of the Assam so-and-so does not have the jurisdiction or authority to issue the show cause notice. Notices dated 13/2/2022 and 18/6/2022. Under such circumstances, the question arises as to whether the issuance of the said show cause notices is an abuse of the process of law. It is pertinent to observe that both the show cause notices were issued on the basis of certain test reports given by the Central Drugs Laboratory, Kolkata, or in other words, is not based with, or in other words, the said show cause notice is, or in other words, it cannot be said that the said show cause notices were issued without any materials. First, it is also very pertinent to mention that these test reports are done by these test reports are made, have been given by experts. And this court does not have the expertise to decide as regards the legality and validity of these test reports. It is further pertinent to observe that even the respondent numbers 1, 2, and 3, upon the reply submitted by the petitioner on 19/4/2022, did not take it on for themselves to decide as to whether the test reports were in order. The replies, the contents of the reply submitted by the petitioner. The respondent numbers 1, 2, and 3, on the other hand, sought for technical feedback from the respondent number 4. And in pursuance thereto, a joint investigation report was submitted on 24/8/2022, wherein also it confirmed that the test reports which formed the basis of the show cause notices where it confirmed the test reports which formed the basis of the show cause notices. Under such circumstances, it is therefore the opinion of this court that the issuance of the show cause notices cannot be said to be an abuse of the process of law. Consequently, the two exceptions for which permits the court under Article 2 exercising extraordinary jurisdiction under Article 2 to 6 of the Constitution to exercise jurisdiction at the stage of initiation of a show cause proceedings is not there in the instant proceedings. Consequently, this court does, in that view of the matter, this court does not find any merit to entertain the present writ petition in as much as entertain the present writ petition insofar as the challenge to the show cause notices dated 13/2/2022 as well as 18/6/2022. The letter dated 4/11/2022 is just the communication by which the petitioner had been duly informed about the joint investigation report, and the petitioner was asked to do the needful. And as such, there is no reason for exercise of the powers of judicial review in respect to the challenge to the communication dated 4/11/2022. In that view of the matter, the instant writ petition stands disposed of with the following observations and directions. The challenge to the communication dated 13/2/2022, the show cause notices dated 13/2/2022 and 18/6/2022, as well as the letter dated 4/11/2022 is rejected. This court also, number 2, this court also takes note of that the reports which have been submitted by the CDC, Kolkata, Central Drug Laboratory, Kolkata, as well as the joint investigation report dated 24/8/2022 are technical in nature. And the petitioner herein can be given a liberty to explain before the authorities concerned that the said reports are either not in consonance with the applicable testing procedures, or the said reports have not taken into consideration the testing protocol, the required testing protocol. In that view of the matter, this court is of the opinion that the respondent number, who is the managing director, respondent number? The respondent number 2, prior to taking a decision in respect to these so-called proceedings which have been initiated on the basis of the so-called notice dated 13/2/2022 and 18/6/2022, should give a personal hearing to the petitioners prior to taking any decision. Anything more? Interim orders, if any, stands vacated. First, no costs. No, that is joint investigation report. No. Kindly come there. Kindly come to this.
150.
156.
Inspection report was with regard to the debarment.
Yes. It's not a joint inspection report, it's the reply, my lord, to the reply made by the petition, which was communicated by the letter dated 4/11 to the petitioner.
No, kindly come to page 191.
No, Lordship will see, my lord, 4/11 for a moment, page 140.
No, 411 is no. Kindly come to 191.
Bye.
This is with reference, this is the letter which went from the AR to the assistant controller.
No, that is the debarment part, my lord. In the present petition, it's this report that they have challenged. Well, page 156 is under challenge.
No, he has challenged only 411.
4/11, by 4/11, we have communicated the reply of the.
Understood. 411 he has challenged. He has not challenged that report.
Yes, report.
That is what I'm saying.
Not the joint inspection report. Lordship will say the letter dated 24/8/2022. That's the letter. It's a mail.
No, kindly come to page 192. I'm not saying otherwise.
My lord, 192 is regarding manufacturing unit, where the factory was, my lord, verified.
No, this is 24A.
There's another thing.
No, another-
Just have to look at page
156.
140 is the 4/11/2022. Their reference may be said, feedback received from the office.
Lordship will see 140, then my lord, 156. 140. 4/11, which is under challenge.
Right, this letter, they have given us a copy of this letter
Yes.
at 156.
156.
140.
140 and 156.
140.
140, 4/11 of the.
No, Mr.
The dates are same, but.
No, kindly come to page 191.
191, Lordship will see 192.
192 is,
Manufacturing site.
no. You see, that is not the word. Joint inspection report of so-and-so, this is of 24/8. Now kindly see what has been come up. Kindly see the observation, remark at page 195. This is the report on the basis on which it has happened. This was forwarded by 411.
Lordship will see, my lord.
Okay, what did you forward by 411?
411, my lord, 156 was forwarded by 411. Lordship will see, my lord, 156 for a moment, with reference to the trailing email and based on the review of the enclosed letter that is the reply petitioner submitted in person to the show cause. Since it is a technical reply, we have forwarded to the assistant drug controller, and they have given the technical reply. Whether it will be as per the schedule or not.
This is given, this is a letter written from, in respect to which document?
Document, my lord, that reply the petitioner is not a part of the petition, but they have replied. Lordship will see, my lord, 140. Just
Kindly
clarify
come-
on the technical.
No, kindly come to this, kindly come to page number 184. This is what has been written by your people only. Kindly come to here. Kindly come to paragraph 8, 183. That with regard to the so-and-so, the assistant drug controller subject replied by the email dated so-and-so against the so-and-so. The reply received by here, the reply is so-and-so, so-and-so, so-and-so. The samples were again were sent for tests to the, or analysis to the medical area for Iman who declared they have no sons.
My lord, this is the additional affidavit which the petitioner filed to place on record.
No,
the
this is your
subsequent
affidavit. This is not an additional affidavit. Why you are confusing?
yes,
This is filed by respondent number 3. You don't know what was the
No,
file. Kindly come here. Subsequently, page 181. Subsequently, the reply received from the drug control department was communicated to the petitioner by letter dated so and so. A copy of the letter dated along with the email dated is annexed as annexure 2. Now kindly see the annexure 2. This is the letter. Then this is 190.
190.
190.
This is the
And
communication.
no, wait. And thereupon, this happens to be a part of it. This 191 is the part, and this is the joint investigation report. Because kindly see what does it say. You see, the debarment question is on the another thing. There, the report is on 2/9/2022. Kindly see this document. Why I say so. Kindly see at page 213. Where the additional affidavit has been filed. Here it says, you see,
My lord, may I clarify, 191 is, my lord, annexure number 3, it pertains to para 15. Yes, regarding that, my lord, inspection in the unit, my lord. Also, we see para 15 at page 186.
kindly see page 191, joint investigation with respect to testing the sample.
No, it says, well, that's why, my lord, content says, Lordship will see this with reference to a letter number so and so received from you, wherein in this office has been carried out a joint investigation. So
Yes.
it's department part.
No, you are not understanding. The moment you got this letter, his reply, you sent a communication to the respondent number 4 on 28/5/2022.
Well,
The respondent number 4 wrote a letter to the drug controller on 29/6/2022. On the basis of that, the joint investigation was carried out. And in the joint investigation report was forwarded on 2/9/2022. This was given by the deputy drug controller to the respondent number 4.
my lord, he will reply to that also.
Yes, and that. And therefore, this is the bandage which is there. Therefore, it categorically says about the, because as regards the manufacturing premises, kindly come to page 213.
Yes, ma'am.
Kindly come to the third paragraph.
Yes.
What is the date of the inspection?
219.
So this is different,
My lord, my lord.
wherein adverse report has been highlighted with respect to your manufacturing facility as is clearly established. And therefore, this document which I have kept on as marked as X is different.
Well,
What is the order you are seeking to for review?
And page 20. You may kindly say your lordship's order dated 18/6/2024. 18/6.
Yes. Yes, what is the wrong with the order?
Lordship's order dated. Page 27. Lordship's order starts from.
Yes.
Really?
One of the main ground on which this petition was rejected was that there was a window open, opportunities were given to us, but we did not avail that. That too late. And therefore, I thought if you of the judgment, more particular paragraph 4, 9, 10, 11. Third. First, I'll place paragraph 4. In paragraph 4, the lordship has said that it's an admitted position that the petitioner did not avail such opportunity as was granted by public notice dated 4/9/2017. Now kindly see at page 62. Page 62 is the public notice.
Yes.
And public notice I'll just read it. Board is receiving subsidy claim of credit linked project under commercial horticulture scheme and cold storage scheme for the cases where the term loan has been sanctioned on or before 30th/4/2016. There are two public notifications. The first is 15/8 and the second is 4/9. So if your lordship will see, if for convenience sake, if your lordship turns to page 63, the first public notice which was issued on 15/8. Next page. Now this is the beginning.
What is the date of this?
15, it was published on 15th August 2017. Down below the document, find that page, please. National Horticulture Board has introduced in principle approval scheme with effect from 1st April 2017 for its credit linked back and their subsidy scheme on commercial horticulture and cold storage. Online application in prescribed format will be accepted only for the new project where the bank has sanctioned term loan on or after 1/4/2017. Online applications will be accepted between 1/9/2017 and 30th/9/2017. Kindly note this date.
Now, in your case, your bank has sanctioned on 30/3/2017.
9/3. 9/3.
9/3/2017.
9/3. It's recorded by your lordship in paragraph 9. In paragraph 9, your lordship has recorded at page 31.
9/3/2017.
9. Now you see, by both these public notification,
No. 9/3/2017 is the bank have sanctioned.
yes, the loan was sanctioned.
Sanctioned 600 crores.
Yes.
600 crores. Lakhs or crores?
Thanks.
Lakhs. And 30/3/2017, you filed the application.
I filed the application for LOI on 33, just within 21 days of the date from date on which the loan was sanctioned. 33/2017,
Ah.
that your lordship will get at page 60.
Okay.
And this was, I will say now, because I have their affidavit, that this was deliberately misread, as if it's an application for expansion of the existing cold storage. And I have the thing, if your lordship goes to the merit, I'll explain everything. Your lordship will see 3/3/2017 at page 60. Reference, your lordship.
Yes.
With reference to subject cited above, we would like to state that we are setting up a cold storage
with a storage capacity of 11,000 metric ton for storage of vegetable fruits at Palasbari Road, so and so, so and so. Now, we do hereby submitting the following documents for issuance of LOI for setting up cold storage under NHP scheme, namely capital investment of PDP for construction of the cold storage, and these are the documents which are required. Now, your lordship will kindly see at page 61, their letter, how they have returned it. It was not rejected, it was returned.
Yes.
Was returned by later dated 3rd of April 2017. Please this with a reference to your later dated 30th May 2017, whereby you have submitted project proposal for extension of cold storage. My application is not for extension of cold storage. It is for construction of cold storage. We are setting up cold storage. And now I will tell your lordship how it was deliberately miswritten.
Then
Then I kept approaching them, but I didn't know.
you didn't approach them thereafter.
Yes, I have approached, I have made a statement below.
No statement would do. Where is your document? You don't approach somebody by, yeah. Where is your document for?
Well,
We have
first-
not mentioned, no, Mr. Mishra, these are not a case of review. It's a case for, what you call, appeal. You file
all
appeal.
right, only two things you kindly hear.
Yes.
One is they are impugned communication. Kindly come to page 77. 77.
Yes.
The reason why they have rejected. Your lordship will see the third part. It is further informed. Lordship, it is further informed on perusal of the document forwarded by you. Punjab National Bank, Fancy Bazaar, Gauhati has sanctioned term loan of 600 lakhs. In the instant case on 9/3/2017, as per available record, the promoters have neither obtained LOI or NHP, nor get registered their project online with NHP during validity period of 1/9/2017 to 30/9/2017. This is when I submitted, they have rejected on these two grounds. The bank, there is a provision for bank to submit. The bank also submitted, and then they rejected it. Next page, your lordship will kindly see on the same ground. On the same ground.
Yes.
So these are the grounds. Now your lordship kindly have that guideline of 2014 we've given to your lordship.
What does it say?
The lordship will come to page 22. Of 21 of the guidelines.
Of the judgment?
No, these guidelines, my lord. We get it is on record. We can provide. We have it.
Yes.
Hello, this 15 came 2 months after that, but I'm reading from 14, which was given to your lordship initially. Page is of course same, page 21 below. Page is mentioned down below.
Yes.
Clause 9. Letter of intent will be voluntary for the promoter and would be issued only on the request of the promoters. Page number 20. Clause 9. This will not be required for claim of subsidy. This is their own guideline. So this is one first ground.
No, here the question is simple to the effect. 9.3 was your sanction loan.
Yes.
You submitted the application on 30/3/2017. It was returned on 3/4/2017.
Yes.
You took back the money of 1,000 rupees, 10,000 rupees.
They said it is been like we have made a
You took it. You did not challenge this 3/4 then.
3/4, of course.
Then in the year 2018, you applied afresh.
And I applied under provision.
No, you applied afresh.
Yeah, no, I have not applied afresh.
Let us see
Not
your 20, no, let us see your 24/11, 24, the 2028, 2018 document,
73,
page.
73. On top, it's what you. My lord, 73, we applied, this is 24/1/2018.
This is the application by online.
Yes,
You did it on, what is the date?
24/1/2018,
24/1/2018, 24/1/2018.
page 73.
Yes. In there, you have therefore foregone your earlier application. What is the ground of review?
Well, I'll place what is the ground of it. Kindly come to page 82. Page 82.
Yes.
This is an application by the bank, Punjab National Bank, and it is under chapter 2 of the guidelines. Kindly come to page 22, madam,
Page?
of the guidelines. Who can apply?
Understood, but this is 11/7/2018.
Correct. May I just put the one? This document was not part of the petition. Now they are taking leave.
No, my issue was
Wait,
very simple
yes.
out here. There's nothing, no
Why-
ground, Mr. I think we
But
dismiss.
just hear me for 2 seconds. This is a case where your lordship has held that we did not apply within the period, within the window that was given to us. This is there in paragraph 4 and 9 of your lordship's judgment. If your lordship will see the public notice, who could apply? Only those whose loan was sanctioned on or after 1/4/2017, I don't come in. Then subsequently, they issued a notification on 4/9 that those projects where the loan was sanctioned on or before 30th of April 2016, if it was 17, I would have come in. So, and your lordship has said,
So therefore your case has to be brought out in that manner. That is not your case before before when we were taking the petition. Now the question comes in. Now with a good counsel out here, you cannot now say that a better argument is being made, that argument was not made by the earlier counsel.
with all respect, this is the case of non-application of fine. Non-application of mine.
You should have challenged, no, Mr.
So we
Mr.
can challenge that there is no issue.
You should have, no, you should have challenged that you were not given an opportunity. That is not your case.
So, but then your lordship has held that. Your lordship has held that we did not avail the opportunity. Where was the opportunity? This is a question that I asked myself. There was no opportunity. And LOI is not required. I have placed it clause 9 of their own guidelines. And therefore I am seeking. Now, non-application of mine to the relevant provision of the guidelines would also, my lord, will be a ground for review as held by my lord Federal Court way back in 1949. I'll place that decision.
No, I did not, kindly come to paragraph here.
Paragraph?
See, paragraph 4
Yes.
this is not a finding by this court. Kindly see, before further proceeding, this court finds it very pertinent to take note of another public notice which was issued on 4/9/2017, which has relevance to the impugned communication dated 1/8/2017. The said public notice dated so and so was issued, thereby giving an additional opportunity to those units who have availed term loan on or before so and so and have not obtained the letter of intent from NHB. Under such circumstances, those applicants have been given a window to register themselves with so and so on or before 39 and fulfill the eligibility criteria of the operational guidelines of the respective scheme. It is also admitted that the petitioner did not avail such opportunity as was granted to the public notice dated 4/9. So,
But where is the admission?
no, understood. This is a fact. This is a fact on which you did not avail.
My lord, your lordship's observation that I did not avail the opportunity is itself, with all respect, not correct.
This is not a ground of review. Division bench A. Allen. Okay. Heard Mr. D.K. Mishra, the learned senior counsel, assisted by so and so appearing.
One more thing.
Yes.
Para 11 is also on the channel. Forgot to see paragraph 11. The last two lines.
Yes.
Not a single document is placed to show that the petitioner applied in terms of chapter 2, seeking subsidy as per the guidelines. As per the guidelines, it is the bank. I'll show you. It is not promoter. And the bank.
No,
has applied.
understood. But that is a case, is a different case where it is the bank. So, but the fact remains that you did not apply as per chapter 2.
I have applied that. Of course, that was, I can say that I applied because my LOI was not rejected. It was returned by deliberately misreading. And your lordship, for the second, if your lordship can kindly come to page 99. Kindly come to page 99 and you see the conduct. Paragraph 50. Can you see the conduct?
Para page 99.
Page 99.
Yes.
That however, in the meantime, the government by circular dated 28/3/2017, my application I filed my note on 30th/3. Before that, 28/3 changed its policy by issuing LOI and introduced a new system of issuing in principle approval, which may not be issued after sanction of the term loan from finance bank, and also getting technical scrutiny of the project cleared by the technical expert, which is mandatory for consideration of any proposal under so and so. My lordship will see, when they have given me a letter that returning that my LOI application, they knew very well that from 1st of April 2017, the scheme is changed already. Therefore, they deliberately, they didn't want to tell us. So the notice came, public notice on 15/8. So deliberately they returned.
But Mr. Mishra, the thing is like this. When you file the writ petition, you filed it in a different manner. Problem lies there. You should have challenged the writ petition on the ground that, look here, you have not given me an opportunity. I have invested this amount of money and this opportunity was not being given. And thereby you have only permitted those persons who have availed term loan up till given windows up till 30/4/2016 and subsequently those who have got the term loan after 1/4/2017. But what happens in respect to the gap period from 1/5/2016 to 30/3/2017?
Yes.
That is your case.
That's
That
why-
is not what is being made.
Let me just make a last. Can we come to my lord page 48 of the writ petition that was filed?
Yes.
That the petitioner firm states that in a visit to Gauhati office of the respondent authority in the month of November 2017, it was made known that there is a change in the scheme by public notice dated 15/8/2017. It was made known to that National Horticulture Board has introduced in principle approval with effect from 1/4/2017 for its credit-linked back-ended subsidy scheme on commercial horticulture and cold storage. Online applications were accepted in prescribed format for new projects where the bank has sanctioned loan, and you see, on or after 1/4/2017 between so and so. It was made known to the petitioner firm that on 4/9/2017, though another public notice, it was intimated that NHP received subsidy claim of credit-linked projects where term loan was sanctioned on or before 30th/4/2016. For so and so, the petitioner's form's term loan was sanctioned on 9/3, and as such, the petitioner applied here only. Mention, I agree, should have mentioned that we have been deprived. But something is there, man. And your lordship also did not see without respect. When your lordship said that we did not avail the opportunity. Because,
No, the fact, it is a fact you did not.
no, I could not.
It's a different thing. You could
No,
not,
I could
you
not
could
have.
not for which you did not.
So, but my lord, these paragraphs 7 and
But
8,
that cannot be a ground for review.
my lord, let me just place one decision. One decision. It's on review only. This has been subsequently followed in other cases.
Now tell me one thing. How did you apply on 24/1/2018? What was the window in which you applied?
Now, very frankly, well, we did that instruction. Very frankly, I don't have to it here. My application for LOI was deliberately misread. At that time, I didn't know deliberately, but misread, let me see. And it was taken as if it's an application for expansion. It was just to buy time, because I don't think anybody with a little sense would read my application as if it is for expansion. Very clearly mentioned. Now, they deliberately did it because they didn't want to disclose at that point of time. They had received the circular on 18th of March.
Mr. I understand that. That was wrong. All these things are wrong. But the fact remains, my question was to you, in which window did you apply 24/1/2018?
The 24, that's what I'm saying.
Was there any window?
I was faced with a situation where my LOI application was misread, where these two public notification, I was left out. So I applied because there was a form, their own format. So I applied. But otherwise, if you
No. Therefore, my question is, whether there was a window for this 24/1/2018?
No. There was no window.
Then was it post the scheme?
Hello?
See, you are saying there were two public notices. One, in respect to those term loans which were given up till 30/4/2016.
See.
The other is term loans which have been sanctioned after 1/4/2017. So the period from 1/5/2016 to 31/3/2017, there was there any public notice in between for that?
Nothing.
One. No, my question is one.
Yeah.
Then the question is whether there was a window on 24/1/2018 when there was no exception, when there was no exception during this period by issuance of public notices, which was done on those two public notices.
I just filed it. I'm loud. What do I say? There was a format I filed, but surely I'll agree that there was no window. I could not have applied. Therefore, the bank applied, but bank could have, because there is a provision in the in chapter 2 of 2014, and bank has
Where's
asked
the
it.
chapter 2 of 2014?
Well,
This is 2015.
same thing, my lord.
No, not this one. There was another document which was placed before this. In different.
can give you one.
You have the 2014?
Yeah, I'll give you one. But I'm sorry, it's marked.
Yes, I want as notified in the month of September 2014. You have a copy? Yes.
September 2014, I have also everything.
This is the document, yes. Pattern of release of young credit links, guidelines for making subsidy claims and release of subsidy under the commercial horticulture scheme, scheme 1 and cold storage scheme 2.
And kindly come to page 22 of the same.
Procedure for release of a full 100% advance subsidy when paid after disbursement and more than 50% common demonstration. Procedure upon release of proposals involving term loan, scheme provide to release full estimated subsidy. And for the cost norms after disbursement of 50% term loan and final agreement of the acquisition expenses. Upon release of 50% amount of the term loan by the bank to the promoter, the concerned FI which has provided credit for the project shall submit subsidy claim to NHP in the prescribed format number 2 to the state so-and-so, committee so-and-so. Now, my question is, Mr. Mishra, why I'm asking you, was there a time limit prescribed in the scheme?
Well,
See,
as such, I have not seen, not come across.
you look
but-
into this,
but-
you have a look into it. You
Yes.
see, the question of reviewing does not arise, but can I give you another angle for that I'm looking into? Reviewing is very difficult. But if it was no window there, then it's a thing which I can reopen it for you to take it up in the appeal. But the reviewing is very difficult.
No, I got
Because you
what,
see, without the base being there, if it was the argument that because that was never the argument made. Therefore, I'm putting that specific. Why did you apply on 24/1? How that option was available? Because you applied electronically, means there was a portal open. How did you apply? There must be something. Means if these two notices did not apply to your case, then were you committed that if these two notices were the exceptions, were you the other people who did not come within these two notices could apply on 24/1? Have a look at it.
The notices make it clear, Lordship. The board will not accept application if this in principle approval is not there. In principle approval, you have to get from 1/9/2017 to 30th/9/2017. So notices specify that.
No,
And-
but those two notices,
And this application, your Lordship, has been made for in principle approval.
let us see those notices again.
Page 63, your Lordship.
Page 6. Board is receiving subsidy claims of credit link projects under commercial demand and so for the cases where term loan has been sanctioned on or before 34. This is only for those period, those subsidy.
Yes.
An applicant has not obtained a letter of intent from NHP. It has now been decided that under the above category proposals of only those applicants, means those who have got the sanction on or before 34, would be entertained and who registers themselves with NHP on or before 39/2017 and fulfill all eligibility criteria of the operational guidelines of the respective scheme. Board will not entertain any subsidy claim request of cases which are not registered with its within the above stipulated. So therefore, my question is, this notice was only in respect to those term loan which were obtained of those applicants prior to 34/2016. This takes care of this. So the window which is being given is till 39, 2017.
But he in 70.
Now kindly come to the other one,
Yes.
15th of August 2017. So and so have introduced in principle IPS system with effect from so and so for its credit link back subsidy on commercial agriculture and so and so. Online application in prescribed format will be accepted only for new projects where bank have sanctioned term loan on or after 1/4/2017. Online application will be accepted between so and so to so and so. Now here also, his term loan is on 9/3/2017. So therefore, for the period from 1/5/2016 to 31/3/2017, which was there any window given or not? My question is that. And if there was no window given, was the overall window open for which the petitioner could submit on 24/1/2018? My question is that.
24. If your lordship first to the lordship's query of the first query, page 73, when he has applied afresh on 24/1/2018,
Ah.
he had applied for the in principle approval. He has not applied for the letter of intent. So he had forgone the letter of intent.
No, that I understand.
Ah.
So he has forgone the letter of intent. So he is applying for in principle approval.
It was rejected and he had challenged that rejection, not the first rejection.
Understood.
Yes. And regarding
But
your
you changed the scheme
Yes.
on 28/3/2017 and saying that you are not going with the LOI, but you are going ahead with the in principle. This is your change in the policy.
Yes.
Okay. My question is therefore, was there a window as on 24/1/2018 for the period who got the term loan during this period from 1/5/2016 to 31/3/2017? Because the others, 2 notices duly takes care of that.
Right.
And my another question, how did he apply?
He could not have that, so it was rejected. The in principle approval was rejected at page 77.
So in principle approval, was it only given to those persons who have term loan after 1/4?
And registered between 1/9 to 38/9.
So thereby the benefit of the scheme which was given was cut short
Yes.
for those persons who did not come in. So you therefore cut short that.
Yes.
So therefore,
And
he can, you see, then you may have to move by way of a promissory. So
But that policy has not.
Our case is, by one case I have found legitimate expectation. And in fact, it is a substantive legitimate, that except by not, legitimate
and-
expectation. Because they have offered it by a lawful representation. They have offered by not, and on that I have legitimate expectation.
The lordship raised another aspect, the application that was returned. So the vested right has not accrued. To claim a right, he has to fulfill certain conditions. Your lordship was reading chapter 2. So, but the chapter 1, there has to be an application as per the format. That application has not been done. And as per clause 9, the letter of intent is optional. He himself had opted for this option and applied. His application was not as per chapter 1, but his application was for issuance of letter of intent.
So the change policy
Yeah.
after 28/3.
Yes, but he now cannot say that is optional by opting to apply.
No, understood, Mr. Ashram, I understand.
Yes.
But the thing is, the period from 1/5/2016 to 31/3/2017, did you, by way of executive instructions, I may put it, you see, the scheme is by the center. So it is given by the center. So did you, by way of executive instructions, deprive these persons
That
who come within this window?
that may not be so. Your lordship, if your lordship read the subject, page 62 subject and the rejection letter. 62, the subject. Subject is registration of subsidiary claim for project set up under the NHB scheme without seeking letter of intent.
Understood,
So-
but this was limited only to 36.
No, your lordship will read that it is now decided that under the above category, under the above category is not the line just preceding the subject.
No,
And-
Mr. Sharma, that is too far-fetched.
And your lordship may then see.
This is as if far-fetched like what Mr. Mishra is also saying, seeking a review, but this is further more than that.
Then your lordship, that clarification may be there.
My question,
I
Mr.
understand.
Sharma, my question is this. While during the, the scheme being operational, did you take out these persons who come within 1/5/2016 to 31/3/2017?
That answer, your lordship, maybe.
This may not be a case of review. My only question is giving them a window.
That page 77.
Mr. Mishra, it is only giving them a window that this court did not decide that aspect. I'll put it as your submission and then that is your lookout. But I'm not going to review that. But if this is a thing which is there, did you take, then you apply that state of Bihar Suprabhat, na? The Suprabhat steel. 1998, 1 SSC page 1. Yes, 3 SSC or 1 SSC page 1, Suprabhat steel, wherein it was mentioned that those persons concerned, when the government makes a scheme, or the department, or when a scheme is being made, these are made under the cabinet decisions. You cannot, by way of some executive instructions, take out this. So if the scheme was available, but the window was not there for these, wouldn't that be in violation of Article 9? So then you may have a case of promissory estoppel made out. It's a different thing, which is a different case, but not here.
Let's just read one paragraph.
Where?
Page 77.
76.
That's a rejection of the second application.
Yes.
In this context, it is to inform that as per the direction of the Department of Agriculture and Farmers Surveyor, NBA has replaced the letter of intent system with in-principle approval system with effect from 1/4/2017 to facilitate the promoters who have not obtained LOI before 1/4/2017, but banks have sanctioned term loan for horticulture projects. NBA has issued a public notice on its website, so that promoters who have availed term loan from banks for their projects, but they have not opted for LOI from NVS, were requested to get registered their proposal online with NHB during the period 1/9/2017 to 39/2017. Only those projects are eligible for issuance of IPA under the schemes of NHB in which term loan has been sanctioned after. This is second line is.
So under such circumstances, therefore my question again comes back to you. What happens to those persons from 1/5/2016 to 31/3/2017?
So this is LOI before 147, 114, before 1.
Therefore, you are giving it. But in midway, you are depriving many. Because the first notice, so therefore my question is, how was the window available at that point of time? What was the window available?
From this paragraph, it seems they have to get themselves registered from 1/9/17 to 39.
How? Because if he registered under 1/9/2017, if he had registered it, he has not registered
He
it,
did not.
and he cannot register
Yes.
it also. Can he register because of the fact that his term loan is prior to 33/2017? His term loan is on 9/3/2017. So my question is, persons who have between 1/5/2016 to 31/3/2017, how do you treat it? My question is.
And that has not been dealt with because that was never raised also. This instruction, then
No, not instruction.
Yes,
I don't want to bring
I-
this. I will put it as a submission. I will say that was never raised and that was never the issue involved. So it is his liberty to take action.
and this policy was also not challenged, this notification. This 4/9/17 was not challenged, right?
Huh?
This 4/9/2017 notification Or the public notice was also not
No,
challenged.
no, that is not challenged. It's a different thing. They have not challenged because they don't fall within it.
Basically,
We got
they
the
agreed
term
by-
loan on 9-3. Heard Mr. D.K. Mishra. And this one, it will be easier for you to come again. Heard Mr. D.K. Mishra, the learned senior counsel, assisted by Mr. H. Patella, the learned counsel, appearing on behalf of the review petitioner. Mr. R. Sharma, the learned counsel, appearing on behalf of the respondent numbers 2 to 5.
Yes.
Nowadays, the Union of India, they don't appear. You know? None has appeared on behalf of the Union of India on call. This court have duly noticed that in various matters, the Union of India is not being represented. This is an application file seeking review of the order dated judgment and order dated 6/2/2024, passing WPC number 7564/2018. By an order dated 18/6/2024, this court had issued notice. And in pursuance thereto, the respondent numbers 2 to 5 have been duly represented. The respondent numbers 2 to 5 there have also filed an affidavit in opposition contesting the review application, and a reply thereto have been filed by the petitioner. The question arises in the instant proceeding as to whether the judgment and order dated 6/2/2024 calls for whether exercise of review jurisdiction is required in respect to the judgment and order dated 6/2/2024 passed in WPC number 7564/2018. It is well settled that the review jurisdiction can be exercised when the conditions, when either of the three conditions are met. That is, when the judgment or order, when there is an error apparent, that is number one, when there is an error apparent on the face of the record. Number two, discovery of materials which the discovery of new and important matter materials, which after due exercise of diligence was not within the knowledge of the review applicant. Or for any other sufficient reasons. First, the question therefore arises in the instant proceedings as to whether any of the three conditions mentioned above is satisfied. Mr. D.K. Mishra, the learned senior counsel appearing on behalf of the petitioner, submitted that the National Horticulture Board had proposed various schemes for providing subsidy, including the scheme for providing subsidy for upon setting up of cold storage. The petitioner applied being interested, applied for a term loan being interested. Being interested and moved by the subsidy provided by the National Horticulture Board, decided to open our cold storage with a storage capacity of 11,000 metric tons for storage of vegetables and fruits at Polasbury Road. And in that regard, have sought for term loan from the Punjab National Bank. Such loan was sanctioned on 9/3/2017 of an amount of rupees 600 lakhs. The petitioner thereupon applied for a letter of intent as per the operational guidelines then existing on 30/3/2017. However, the said letter of intent was returned on 3/4/2017 without taking into consideration that the petitioner's application was for setting up of a cold storage, not for setting up for expansion of the cold storage. The petitioner thereupon again applied on 24/1/2018 online. However, the same was rejected on the ground. However, the same was rejected by the order dated 2/5/2018. The learned senior counsel submitted that while passing the impugned judgment and order, an error apparent on the face of the record had crept in as much as this court failed to take into consideration that the notices which were issued on 15th of August 2017 and 4/9/2017 in the proper perspective. Elaborating further, Mr. Mishra, the learned senior counsel, submitted Then notice, public notice dated 15/8/2017 relates to those applicants who have obtained the term loan on or after 1/4/2017 and the public notice dated 4/9/2017 was in respect to those applicants who obtained the term loan on or before 30/4/2016. The learned senior counsel submitted that these schemes which were announced did not at any point of time was never withdrawn. However, there was no window provided, there was no exception. However, the applicants, like the petitioner who had got the term loan sanctioned on from 1/5/2016 to 31/3/2017. Either were deprived of the benefits of the scheme which was applicable, or there was no fixed time limit for making such application. And this very aspect ought to have been taken into consideration by this court while passing the judgment and order dated 6/2/2024, which is sought to be reviewed. The learned senior counsel submits that the question of the petitioner's rights accruing on the basis of the principles of promissory, on the doctrine of promissory estoppel, as well as the principles of legitimate expectation, were not taken into consideration while passing the impugned judgment dated 6/2/2024, and as such, an error apparent on the face of the record had crept in. This court have given an anxious consideration to the aforesaid aspect and have perused the materials on record, including the affidavit, including materials on record, including the judgment and order dated 6/2/2024. The issue which is now being urged before this court is an issue which was never urged before this court, were neither pleaded nor urged in WPC number 7564/2018. Under such circumstances, it is the opinion of this court that on the basis of these issues, which is now being urged, a question of the review jurisdiction of this court cannot be exercised. Accordingly, this court is not inclined to entertain the instant review petition, and for which the same stands rejected. without prejudice to the contentions urged in the instant proceedings.
That should be there.
No, this is the point, but this was not urged, Kantan. This will help you.
My lord, I'm being led by senior counsel, Mr. Dean. My lord fixes another date. Your lordship fixes another date. Lord, my senior would like to.
At the request of the counsel for the petitioner, matters and Jones, we listed up things.
My lord, a date may be fixed. A date may be fixed. Why? My lord, if your lordship wants, I can start.
Here the contender is asking for a date.
No, my lord, I can.
My lord,
Huh?
my lord, against this, my lord, lordship has since lordship has passed this order, my lord, my lord, if lordship takes up this matter is, my lord. That is my lord, my lord, prayer, my lord.
Lord, I can, if your lordship wants.
My lord, if we have,
I can start, my lord. Lord. The notification in the cause list shows that lordship will rise at 3:45. That's why it's like. Look, the notification in the cause list showed that lordship will rise at 3:45. That's why. That's it.
Rise at 3:45. Anyway, we'll have it on 11th of May.
Lord, I think. Lord, I think 11.
What is this, Mr. Petitioner in person? So many cases.
Lordship, the order passed on 11/02/2026 in IS 2817 may kindly be produced.
What is this matter about?
Matter is the tender matter. So finally an IS being filed by combining three different petitions. And Lordship, this court also passed order which may kindly be seen so far as delegation of financial powers and rules. And you can see the
What
orders.
happened to the tenders?
Lordship, everything is completed now. In fact, the petitions are becoming facts of lawsuit because tender process has been completed. The lawsuit work has been allocated, work has been completed.
Why should we?
And in the IA lordship, he is asking for initiating criminal proceedings against the official.
Mr. Vachaji, come up with a better case sometime. We don't have the time
Lordship,
out here. Mr. Vachaji, let me tell you one thing. We don't have the luxury of time out here in the High Court in respect to taking up certain dead aspects, dead things. You have any problem as regards some functioning of these authorities concerned? File a PI.
no, Lordship,
These are for PI, not for these type of
no,
matters.
Lordship, kindly peruse the order at least. Order of this court, you peruse so far.
Which order?
11/2/2026.
In which case?
IA civil, IA is 2817.
I
IA 2817,
817.
dated 11/02. Is order.
What is the order? Let us.
11/02/2026.
What does it say? As agreed by the learned counsel for the parties, matter will be taken up for final disposal.
Yes.
No,
I'm taking it up and
No,
saying that
no,
why
no.
should we?
no, this court asked their opposite party to file their objections on my IA. The order there, 11/02.
Okay, my question is, if these contracts have been finished, why should I reopen certain things which is not necessary? It is not, this court is not going to look into all those things.
And lordship, if there
No, no.
any criminal conspiracies there, lordship, we three violent FIR, lordship, will
Go file criminal conspiracy
Yeah.
cases.
No, but my submission is, this honorable court has admitted this IA, he dismissed and admitted, passed the order, two different orders passed. Lordship, can
IA is there, but the petitions are the question.
But
What is these petitions for? That there were certain tenders which have been issued.
No,
Where-
that's why you see the order, your past order, this court, see the order, please.
Which order dated?
I'm showing you. Order dated page 230, page 236. That is of the I, page 236. I, page 230. 236 and page 234 and 236. 50, page 234 and page 236. Then that takes article 299 also India. The tender which was invited is violation of article 299. How you can, say that?
Settled work has been finished.
No, that's different thing. But article
We
299,
are not going to do, when some matter comes up for that issue, on that date, live issue, we'll look into it, not today. After this, what is going to happen today? If I open up this thing today, work has been done, payment made.
no, payment not made. Payment not been made. Payment not
Only
been made.
because of the pendency of the process.
Work has been done or not?
Work is done, that is.
So on the question of quantum merit, these people will be entitled to the money.
No, Lordship, kindly peruse the order. What is the problem? Kindly peruse the order. The order page 234 and page 236. Please kindly peruse the order.
Work has been completed, Mr. Bachchan.
But that is illegally done, no? That is in violation of
Work
article.
has been completed.
Lordship, let's.
I am not going to entertain this type of it. Work has been completed. Why on earth should we look into these aspects? If the work was not completed, payment was made. Yes, you say that the payment has been given more than whatever amount of payment was required, then it's a different thing. Who are you?
No.
He's not
Who
the
are you?
intending bidder.
Huh?
He is not the intending bidder.
Then
Not
No, Lordship, this
participator.
is not a fact. This is, Lordship, please go to the IA completely. Please peruse the IA. If dismiss, don't mind. But first go to the IA completely. Then dismiss is what the problem. If there is no money, dismiss.
IA, by way of an IA, you do not have the substantial rights.
Please,
What is this all IA for?
yeah,
Criminal proceedings against these people.
you say that.
Why should I go and go before that? Go before the authority concerned.
Lordship,
File BNSS.
but Lordship, this court says, no, Lordship,
This court is not going to look into it.
Lordship, this court passed an order saying that matter will be finally disposed, taking it to all these three petitions. So considering including the IA, then they,
Mr. Bhattacharjee, what do you mean by finally disposed of?
Sir.
It may include dismiss for default also.
but in my humble opinion, this is not proper to dismiss the matter because it has been considering for the last 3 years. Order of this court also there for last year continuing. If there is no merit, take them dismiss long back.
Mr. Bhattacharjee, kindly appreciate this matter work has been completed and we are not going to do. How do you see whose mistake it was? Mistake was that of the departments?
No, mistake was what let me submit and you take your own. What's the fact? To award the contract to a single bidder at a monetary loss of 25 lakhs to the irrigation department. Who will be at loss? Irrigation department is a monetary loss because of all this criminal conspiracy. Work was alleged to 6.40 crores, not a small work. And to a single bidder on single tender at per day, estimated. So at least go to the IA companies, at least then you, Lordship is fully competent to decide. Lordship is fully competent to decide the matter. Who am I to question? But at least go to the IA.
No, not IA. Mainly, IA is not business. Why should we look into the IA? Come to the repetition. Come to the repetition. Forget about the IA. What is your first repetition? Which repetition?
4185 loss.
What about the IA?
4185 loss.
These are the only two repetitions?
Three repetitions.
There is one delegation of financial power.
Third one is lordship regarding delegation of financial
Okay.
power.
4185. What is your case? Let us-
Prayer, lordship, kindly prayer.
And see the order.
We'll see the order. First, what is your repetition? Let us. Under such circular, respectfully prayed that admit the petition calling for the respondent number 5 specifically to stop the tender process, including allotment of work, and if allotted, that to be stopped with immediate effect till disposal of the petition. this order, was there any stoppage?
No,
So work has been allotted, work done, with petition has become infructuous. Next,
next thing,
what is
same
the second writ petition for?
who works no, next one is similarly situated.
Suspend the work order dated so and so. Issue notice why criminal proceedings should not be initiated against the superintending engineer. So
And he is
so, so and
implicated.
so, so and so.
His lordship, see the order.
Work prayer A has become infructuous, there was no stay done.
Oh.
See, kindly come to page 13 of your writ petition,
Second.
6431.
Yeah.
See the page 13.
But,
Problem arises, Mr. Bhattacharya. What has happened is, either you should take the assistance of a lawyer, or if you want to do it, you should do it properly. What has happened, you see, Mr. Bhattacharya, yes, you may have a good case, a good point, but the fact remains, the relief which you are seeking for is what? No, Mr. Bhattacharya, kindly see, kindly come to page 13, read the relief.
One thing.
but I read it, but one thing, that means, kindly peruse the order, dated 24.
Forget about the orders. I'm asking you, what is the relief at page 13? Read it.
Yes, I got it.
Relief, you are seeking the suspend the work order issued. The court should have passed the order, first of all, what is required. You should have sought for that this work order should be set aside. This is your relief which you should have sought for. What you are asking for? Suspend. That is an interim relief. Get the point? So therefore, when you want to do the matter, either if you want to do the matter, it is a different thing. You have to do the matter in a proper manner. And you are a bidder. You can very well, you have the, like to be a litigant as well as also a petitioner in person. Very good. But the problem lies here. As of now, if I say, how do I interfere with the work order? Tell me.
Because work order can be interfered because it attacks the Article 299 of Constitution of India, so-called work conditions constitution.
Where is your relief?
Relief
Where is your relief?
This is the order. This is the order. This is the High Court. This is the Supreme Court judgment.
Supreme Court judgment, everything will be taken care of. Mr. Bhattacharya. Supreme Court judgment, everything will be taken care of. But the fact remains, every case has its own facts. Okay. Now, here, if I say that, okay, the work order is bad, having not been done as per the law, or 299 has not been followed, Article 299 has not been followed, that is your case, if I hold it. Then my question is, the next thing the contractor will come up and say, before an appellate court, where is the relief?
That they under Section 70 is there. Section 70 of contract is there to get relief.
My question is not that. He will ask, where is the relief you are asking for? Tell me.
In my humble subject next. When a government, when a tender is invited on behalf of President of India or governor of a state, as the case may be, that should be as per Article 299 Constitution of India, read Section 175 of Government of India Act 1930. And if it violates that, it is no issue whether work is executed or work order issue, that is immaterial, that is as per constitutional provision. That's understood. So this delegation of financial power says, chief engineer minor irrigation and additional chief engineer implementation, they have no business to redelegate his power to their subordinate officer, because subordinate officer are not empowered to invite the tender amounting to 2 crores or 5 crores. He is competent to 1 crore only as per delegation. And Rule 5, Roman 7 is very much in record. That is a financial communication, financial notification of issued by the finance department of Government of Assam. What they say, the person who has conferred the delegation, he cannot redelegate his financial power to any other officer, either in part or in full, without concurrence of finance department. This is very clear. So, chief in a minor irrigation to award the contract to a single bidder at single at per rate, at a monetary loss, what he gave, he unfortunately gave the delegation. He's not taking any contempt.
Go and write a letter to the finance department.
No, they have made a respondent party. They have made a respondent party. It is ordered.
Write a letter to the finance department. Go ahead. Write a letter to the finance department that do look here, this is happening. And you know one thing, Mr. Bhattaji, rest assured is one thing. The finance department, the moment he gets that letter, would be happy not to pay him a single penny. That I can say you with guarantee. Finance department at any point of time, a person who is entitled is not willing
I am
to
not
give.
competent to force you to get me order in my favor. That is fine. But at least I can request pray you that you go to 3 writ petition as my IA.
Who will finish?
That's a delegation 2485. He there. There another petition 2485 delegation of final powers. So go to 3 writ petition.
The third one otherwise will also become influxed in view of the two petition.
No, my submission is contractor has been asked by an order 22/4 why your payment will be stopped by this court. He did not reply. Even time was given for 4 weeks. Last 2 years gone, he did not. So I have nothing to say. First, you go through the entire documents, 3 writ petitions as well. I pass it. I'll accept it. No problem. But question is, without going through and perusing these 3 writ petitions properly and going to the IA, you don't pass the order. At least take reserve the order. No, that is not-
No. This is not a case of reserving the order. This is a case of dismissal right away. I'm not going to do
I
anything.
don't find the ground of dismissal because this is Article 2
This
and the
is-
violence.
No. What is 2485? 2485.
You see the orders also. Order passed. This is not an issue. Issue is the question of, legal issue.
Cancel the 2 work orders issued by the superintendent with immediate effect as it was in contrary to so and so.
Yes.
And there was no stay.
No still.
Court should have passed the stay. Without a stay, it can't happen.
And that is go to it. And you also, this court also passed the order.
I've also passed the order. I've issued notice only. I didn't grant the stay.
No.
Then, and the reason why I have issued notice on 19/7/2025 because the work orders are dated.
No,
What are the work
for
orders
me-
dated?
For me, everything is acceptable from the.
Work orders are dated of 2023. Formal work order period of work is within how much?
It's maybe not the problem, at least go to the matter.
Hmm? Period of the contract is?
It's not.
And where is the agreement entered into?
Hey, what?
Agreement entered into?
Agreement means?
Agreement.
No, I was,
There must have been an agreement entered into when your proceed to work was there, isn't it? Who has entered into the agreement?
I am challenging the tender process and delegation of final power and Article 219. An order passed by different courts, they are in my favor, all the orders, not against me, not a single word against me. And as a matter of given dismissed long back, three years from last 2020 August, it could not have continued till now. Definitely some merit is there.
Who is response number 5? Chief engineer.
It's fine in there.
No. Response. Accepted the tender by accepting the wage and entitled them. Immediate concerns of the person issue to them. Or people. That's all. Hey, Mr. Vaidya, tell me, why do you have the habit of enclosing various mentioning about documents and without filing, bringing on record those documents? Can you see the affidavit filed in 2485?
They did not reply additional affidavit also. The order passed by this court.
Why you are mentioning many documents at paragraph number 8? Why haven't you not placed with all these things, the documents? Bring these documents tomorrow. Please, these matters tomorrow at 2 p.m. for final disposal. I'm dismissing your petition because it's a different. But this is, you bring these documents because these are the documents which are necessary and it is very, doesn't inspire the confidence of this court. When you are mentioning about these documents where it forms the part of it.
It is my fault, I have not annexed.
Then we will impose a cost of 50,000 upon you. 50,000 minimum because of this. And this 50,000 you give it to him for waiting the whole day and getting a dismissal.
That's not a problem. Problem is justice to retain.
It's not justice to
Not-
retain
not
you.
necessarily
And,
my
Mr. Bhattaji, the question is not there. The question is, how do you take care of these situations? We don't have the luxury. There are all matters are always pressing. Kindly see there are a lot of lawyers out here. Anyways, yes, Mr. Chaudhary, what is there? Let you, list the matter tomorrow at 2 p.m. for final discussion.
Item 27 may I pray for listing on a short date. Item 27 for hearing.
Okay. What is the matter about?
Madam, this is regarding settlement of a fishery matter. 4 years have passed by.
Okay. When do you want it?
Any day convenient lordship as early as possible.
Let's have it on 28 at 2 p.m. Yes, what is happening out there in the CGM?
My lord, the process of shifting is advanced to a large extent. Almost 80% has been shifted. By today evening, probably it will be complete. Regarding paperless court, my lord, we have received a fresh proposal from the High Court.
Yes.
Either the communication one has been received by us and the proposal that we had submitted.
You have received the proposal?
My lord, we have received, my lord.
Mr. LR, you
Yes, my lord.
one day just before the date fixed by this court, you give this proposal directly. Asking the register to provide. What were you waiting for all this while from 7/4/2026? Where you, this aspect where you could have done it much earlier. They could have then in the meantime had provided it. Why on earth did the last date this had happened? Yesterday. It doesn't look nice. Huh?
That's why the courts are required. That's why courts are there.
indicating the appropriate head of account along with the amount required for placing the same before the finance department for necessary budgetary approval. And then this is being given on 23rd of April. They have also provided today.
Today.
Anyways, you
Well-
do one thing, we'll do one thing. This has been given out here, you immediately send it to them.
Yes,
By
my lord.
next day, they'll let the finance.
Yes, my lord. Yes, yes.
But a proposal for entire court. Yes, it's for the 5 courts.
Yes, the thing is like this, why the problem arises this. You know, we are asking for paperless courts, and why you are giving it for district and subordinate court complexes? Huh? Where is the PMP? Where is he? Only come here. First and foremost, you see, we have the hardware. We need the software. I'm told that we are also trying to build the software in-house. If it happens, it's good. But how much amount will be required for initially for the 5 courts? This is the proposal for all. They have asked, the LR is asking you only for paperless. Why you are giving everything?
Lordship, actually, at the in starting of the year, we have to
That you give.
Yes, Lord.
You give it separately.
Yes, Lord.
So that we can also impress upon them to immediately release for the 5 courts. While everybody is noticing how it is functioning. So give a separate proposal that can wait for some time. What is the urgency? That is what we are repeating on all this. But please give us the preference why. Give a proposal immediately for this 5 courts initially. Keep your caveats that we are proposing for this, the rest of the 17 courts or whatsoever, we give a separate.
Yes, Lordship. In addition to this, we can place a separate proposal for only 5 paperless courts. Today only we will. Lordship, we have. We have given it headwise, Lordship.
Where is the drawer? He is picking up all this. Because as of now, we don't, Mr. The name Ashish. Kashyap. Mr. Kashyap, you have to also understand, we don't want this paperless court to be something like an instrument which is said there, no? Just next to you. There's one instrument. No, that was a photocopier which became of no use. Similarly, like these two, which were never used. I put it to use for putting some warnings. It's a different thing, but otherwise it is of no use. You see, you have to also understand a very important aspect. we can initially start with around 5 paperless courts. Because we also have to have the materials, na? Your digitalization of all the matters is also required to have 19 paperless courts. Otherwise, those 14 paperless courts would become useless. As of now, we have been digitalizing, or for the purpose we have already put it online, those digitalize the dispose of records to a particular extent. From November 2025, we have made online filing mandatory for various aspects, and if the filing is being going on. So with these filings being going on, these are the only matters. Now, if we don't have the earlier ones, how is the court going to function with a paperless court? So therefore, it is required for at least for 5 courts. We also have to understand the state's financial. Although they say we have a lot of money, but then also let us also understand the state's finances. If we can get hold of this 5 and it can be worked out, let us then see how it works out. So all these other proposals for the year beginning will go on, that you kindly give it. There's no quarrel. But for paperless court, make it only for 5 for the time being, and then deduct it. So for this paperless court, with this required only this amount for the time being, something around 3.5 crores or something to the effect. Then you can get the money out there. Remaining years, isn't it, Mr. Gogoi? Yes. Then we can further proceed. Later, experiment also how the paperless courts work. My brother is very good with these people, all these things, techno savvy. For us also, we have to be also thought about it. So therefore, let us first, you need to give that, how much amount it is, and give that particular proposal. This proposal of 23 crores in this, you may give it for other purpose. For all the other things for next year, you require these 23 crores. It's a 39 crores is a different thing. They will look in, put it out there in the budget, how it is to be done, that would be done. But as regards the paperless course for 5 courts, how much it is? Yes, Mr. Dwara. How much it will be required for the paperless courts for these 5 courts? How much we require now? Not this estimate which Mr. Kashyap will give.
Last time we submitted for 3 crore 88 lakhs. For 5 courts.
For this amount, 3 crore 88 lakhs.
Yes, for 5 number of courts.
So therefore, put that proposal to them. 3 crore 88 lakhs, whichever it is, then we can take it up with them. And they will also have they cannot give up the 39 crores and give everything or mixing it up.
Exactly.
Because his letter, which is being written by the, the LR, is you are therefore requested to kindly file a fresh proposal for paperless course in the current financial year 2026-27. So this, it is there, but initially we require this. Put that proposal out there.
Yes.
And apart from that, you can for other courts, other 14 courts, you give it later on or together, you can give it, but initially we require for as a pilot project for these 5.
Yes, sir.
This may be given separately, ma'am. Separately.
For the entire.
For the entire.
Because they have to cabinet there, my lord, budget has not been placed till now for this sector. It's an interim budget which are functioning as well. So after June, that can be given, ma'am. We consider for the
But
rest of the-
initially,
This can be considered.
5 or 3.8 immediate.
3.8, if we can give it, then this will come in, then we can very well take it up for this particular 5 courts. Pilot 5 courts. So the remaining will there. So therefore, you prepare proposal in that manner, not in this manner.
Yes, ma'am. Yes.
Can give.
Stopping you giving this proposal separately. Yes. But we want to ensure that at the earliest, at least let these 5 to start operating.
Because we also have to have materials. Huh? Yes, the materials has to be there. We don't have so much of digitalized papers to have a digital layer. This will take.
First filings are there. You'll have to digitize all the old records. Then only you can feed into the computer.
Yes, sir.
Then only all courts can have this.
As of now, I think for new pending matters, you have only from 2025, late part of 2025.
Yes, we have scanned all the disposed cases, actually, Lordship. We have scanned the disposed cases.
Forget about it. This is not helping.
Pending,
us for paper.
pending.
For paperless, we
Pending.
need all the pending cases.
All the pending cases.
So for relating to pending cases, those press cases from November, they are filed online, so digitized already done, kind of. Remains is that period, which is daily will.
So these 5 courts, do you mean to say that the moment we come up with this, these 5 courts will only take up matters from November 2025? Only for 4 months? How will it survive? Means the courts will have to rise around 11:30.
Ultimately, even if it is a paperless court, will be in a hybrid mode with paper and with paperless.
But that makes no sense. So therefore, it's what is the progress in regard utilization of those matters around? You have to bring it around by 2024. By the time you start the pilot project of paperless.
Yes.
Yes. Any financial problem there? Or digitalization?
Then, but I think the E-committee is paying that. The government of India is paying that. So I think we have to act fast on that aspect. Yes. Then only we can have this paperless and provide now a separate proposal for that. Paperless only for 5 courts for the time, because we cannot afford, they cannot afford, and we cannot also ask them for 19 courts today and then just give the money out here so that nobody can use it. It makes no sense. The machines will become that. So therefore, you have to give it only for 5.
Yes, ma'am.
So we are done with this paperless. Housekeeping, what has happened?
Housekeeping, my lord, the head of account has been created for the time being, my lord, for the High Court. And for the District Court also, the proposal we have moved to the finance and it will be soon taken care of. What we have done, my lord, we have also, in a deliberation with the Finance Department, my lord, we are, right, by taking into consideration the concerns raised by the Honorable High Court, Lordships, that the Finance Department is considering of exempting the High Court as well as the entire judicial establishment from the purview of GEM, considering the problems that is being faced.
So let me tell you one.
Yes, ma'am.
You see the Constitution gives a different independence. A salary of a registrar or assistant registrar, a staff or anybody is not at the discretion of the state.
Yes, ma'am.
These are
Consolidated.
paid as per from the consolidated fund.
Yes, ma'am.
The salary of the judges are also from the consolidated fund. So there is a question of independence of the judiciary. This is the and this is the basic structure. Now tomorrow, if the High Court is to, okay, for their salaries for the person is okay, but if the High Court is to run, and you put the High Courts to the knees by saying that every amount you are going to do it, something will happen. So you need to come up with some proposal so that the entire housekeeping charges are looked into. And thereupon, you have to budget it. That this is the budget. Just for example, for the High Court judges or for the registry of the High Court, you have already budgeted it. When you place the paper as per 202 with the bill of accounts, the moment you do it, you have already budgeted. Similarly, for housekeeping, you have to budget it. And then in that budget, you have to place it to the effect that this is the requirement. And this amount has to be put to them. And it is, if tomorrow, if anything goes wrong with the High Court in doing something, some officials do something. Here, you don't have the power of disciplinary. The power is with the Chief Justice. So therefore, you have to understand, you cannot put the High Court in this manner. So this is how it has to be done, Mr. Gogoi. You have to understand, what is happening is, any amount out there, you have to fall upon the state. Then what is the independence of the judiciary has to do?
Mr. Gogoi cannot read, and his mindset should go that High Court is kind of a department of a state. It's not there. Everywhere they are equating with this department. Department should do that, this department. It's not the way.
And because of your action, the High Court Registry now has developed that. And therefore,
Their mindset is also like that.
And therefore, that day for the judges clerk's job, they are asking for an employment exchange certificate. This is the sad part of the High Court. They have also, because of the fear which you have installed.
So they have changed your mindset for you treating them like a department. So now they have started thinking that we are a department under government. So whatever is necessary, will have to go to alia or somebody else.
So these changes should also appear in the FinAssam portal also, because our staff on many occasions finds it difficult to incorporate these things in FinAssam. They say it's,
See,
it's
it will
approach
require
is
some time,
holistic.
deliberation should go on.
Fine.
It is, if necessary, you have to change the software for the purpose.
Exactly.
Yes, yes, madam. Once the JM is exempted, madam, it will be done. Necessary.
Jane, we are not saying about
Le-
Jane. As a whole, the concept of the
Yes, madam.
department and their executive.
Definitely, madam.
So if
Definitely.
this mindset in then along with the mindset, the whole system, you have incorporated High Court as a department. That cannot.
Right.
That is what.
However, we will implore upon you to accept one software which we have made with the translation. Now, what has happened is, as you are aware, as Assamese language, this doesn't have a Unicode. So therefore, you in Google or everything, you can't get the translation of Assamese. So we have developed an IIT software. With the IIT, we have made a software. And in fact, this has done very well. When we placed it in the Supreme Court last time, it was done very well. But the fact remains that the more you use it, the more it's better. Now, one page of SEC Online, one page in English is translated to Assamese in 7.5 seconds. So the more it is being used, and if the state government uses it, because we don't have so much of translators. The more you are using it, you also have some translators. Yes, so if they keep on using this, because if we can share it and use it, and if it is being corrected, the software becomes better.
Because you learn to use this. Yeah,
It's a,
you learn.
people learn.
It can be taken up with the IT department
In
of
fact,
the
I
government of
think,
Assam.
The government of, we have requested the government, and the government has
Yes,
also
madam.
requested to use it.
Yes,
But by question is. if
the
you
data
use
will be
it,
fed
The more you
in the
use it,
system.
that becomes better. Like, for example, the Bengali and all, there's no problem because of the fact that it is a language which now is weighted by the Google. So there's no problem with that. Manipur here has no problem because the script is same. We have a problem because only difference between Assamese and Bengali is the raw. Anyways, then we do one thing, shifting of the CGM complex, funds for paperless courts and creation of head of account. So that has already been done.
Yes, madam.
It's being done.
It's being done.
Not done.
It's still now is being done.
Okay, so then we have it on 7.5.
Yes, ma'am.
Regarding
We can.
shifting, after the shift, they informed that by 45 days, we will able to complete the entire segment. It's okay. No, it's okay. Let us have it on 7.5 again for the other matters.
That's not for season.
Well, not for CGM. We
Yes,
will
ma'am.
record
Yes.
it that they are shifting, and today the entire shifting will be completed.
Yes, yes,
And remaining would be, and thereupon it will take around 45 days.
yes.
Then we look into it. And as regards the funds for paperless court, you will provide the here properly. Heard. No. Pursuant to the order passed by this court on 7/4/2026, the instant proceedings is listed today for an update on the following aspects. A, the shifting of the CGM complex. B, the funds for the paperless courts. C, creation of the head of account in respect to housekeeping. Then again, madam, put it a heading, huh? Heading, the shifting of the CGM courts. We have been informed that in pursuance to the order passed on 7/4/2026, the Assam Administrative Tribunal has already started shifting to the second floor, no? To the first floor of the GAD building.
Malad, just right now I have received a message from the Commissioner and Secretary GAD that he says that it has been completed. I mean, shifting has been completed. Yes.
Submitted. And pursuant to the order passed by this court on 7/4/2026, we have been informed that the Assam Administrative Tribunal have already shifted to the first floor of the GAD building. And the PWD authority would be now taking up appropriate steps for completion of the construction of PWD, na?
Yes, Malad. PW.
For completion of the construction of the courtrooms in the second floor.
In the second floor.
Full stop. It has been submitted by Mr. B. Gogoi, the learned additional advocate general, that the said construction is likely to be completed within 45 days.
45 days.
Full stop. An update be placed before us after 45 days. Full stop. Next, the funds for paperless courts. B. Insofar as the direction passed by us on 7/4/2026, Mr. Biswajit Chakraborty, the learned LR cum secretary to the government of Assam Judicial Department, has submitted that by the communication dated 22/4/2026, the Registrar General Gauhati High Court have been asked to provide a fresh proposal for paperless courts in the current financial year 2026-27, indicating the appropriate head H/A, along with the amount required for placing the same before the Finance Department for making necessary budgetary provisions. On inquiry made by us as to what would be the amount for at least 5 courts to be made paperless, so that the paperless courts can be initiated by way of a pilot scheme. We have been informed that the amount likely, the proposal likely to be the amount which would be needed would be around
3.8 crore.
3.85 crores. Full stop. The Registrar General Gauhati High Court shall provide the said proposal forthwith. Full stop. In addition to that, we also asked the Registrar General of the Gauhati High Court to place the other proposals relating to information technology, relating to sanction for information technology head of account. Separately, so that appropriate steps can be taken by the Judicial Department along with the Finance Department for placing the same in the
Ensuing budget session.
no, this will not be an interim. This is in the full budget session to
In the
be
full-
placed,
Yes, full budget.
which will be likely in the month of June 2026. Next. See, creation of the head of account in respect to housekeeping. We have been informed that both the registry of the Gauhati High Court, of the Gauhati High Court, as well as the Judicial Department of the Government of Assam and the Finance Department of the Government of Assam are taking effective steps for the purpose of regularizing the head of account in respect to the housekeeping. And the same would be done within
15 days. Already measure has been taken. I mean, what I submitted before your lordship regarding that, I said.
when do you want the money? Within
They can pay it, the outstanding amount, they can pay it now.
result. So from there it will be done.
Yes.
So within 15 days,
Yes.
not later than 15 days.
Yes.
List the matter again on 7/5/2026. On which date the other aspects pertaining to the order dated 7/4/2026 shall be duly taken note of. Full stop. The register administration along with the register PNP shall also provide shall also place before us on the next date with prior intimation to Mr. B. Gogoi, the learned additional advocate general, what are the other infrastructures projects wherein appropriate steps are required to be taken.
But one small issue I'd like to flag, my lord. The GAD building, my lord, the lift has not been made functional as of now, my lord. The lift. So which is, I think, already 4 courts are functioning there. We have more courts than
Ramp.
ramp is not there.
But they are working on it, one observation, something will come up.
Regarding lift, my lord, what I have the information, my lord, there was some defect in the estimate, my lord. It is before the district judge, Kamrup Metro.
এই যোনটো আমি হেডিং CGM হেডিংটো তাতে লিখি দিম হা and updates shall be placed before us on the next date, that is on 7/5/2026, as to the functioning of the lift in the GAD building.
Yes.